Yeah. What was the what he just didn't report at all? Oh, okay. Yeah. Got it. Sir. Right. Oh my goodness. I talked to her about this case. Yeah. And it's like nothing. Nature discovery. Yeah. And she's like, you can take a plea to that. I'm like, no, absolutely not. So that was the extent.
Hey.
Right. Seriously, I have no idea. Yeah.
Hello, Colonel. Good morning.
Good morning.
Thanks for putting up all those barricades.
You think you're ready?
Yeah, I didn't mean 4 hours at 4 months in advance. What's going on?
I saw your email.
Yeah.
Major City said she's gonna reach out to,
Lloyd.
to see if they have.
Okay.
they'll put it into.
Great.
So,
If they do, just save
I
everyone.
know, what they're doing is picking them up there in the report, and we try to verify.
Yeah,
them so we can advance.
Okay. Okay.
So I'll let you know.
All right, yeah, because if they are quick hits, then rather than people having to go all the way up there and bring them in here for like, hey, nice to meet you, I'm Judge McBurney, and then they're going back. If we can pop them on a screen, then we could just make sure that the litigation managers put them on their day of, like, my Zoom is a Wednesday. And so I just make sure we add Floyd to Wednesday, like we do with Cobb,
Yeah.
and just take them first or whatever's easiest for them.
Okay.
If they can do it. I don't know. I know we are happy to get beds. So if we got the beds, we should take them. Thank you.
No problem.
Ms. Simpson, before we get started, you sent an email about position 8 on the calendar. I don't know where that person is, but do you think that there's something active for that person if that person comes in? Okay, so we've let Deputy Gordon know?
I have not.
Okay,
Same position, 8.
8.
Yeah.
You can discuss it.
Okay, well then we're good.
Yeah, that's before court, right?
Yeah.
Yeah.
Well, technically, I mean, you want-
Oh, I remember this guy. This is the one who would come in every few, he gets in custody? Yeah.
he just part of being listened.
Yeah,
Yeah, he's here.
We have-
he's here. Okay, all right.
We haven't seen him.
Yeah, right. Okay, well, let's get started. Good morning, everyone. We have a plea and arraignment and inquiry and potential revocation calendar for this morning. And then this afternoon at 1, we've got a quick, maybe it'll take a little while if there's some pleas, final plea calendar. We will hit the plea and arraignment now. Positions 1 and 2 are Cedric Jones. These were transfers from our friends in non-complex, or at least number 1 was. I don't know if that joined number 2 or if they were both transfers. Ms. Rios, will they be yours?
Yes, but I have not had contact with Mr. Jones.
Let me see how recently he was in court in non-complex. Kind of hard to tell. He had his, at least the older of the two, the lower number indictment, he had it dismissed pre-indictment, so he may have thought he's all done. Then he was indicted, had a plea and arraignment with non-complex, and then they transferred it. So I don't know what happened there. Let's look at the newer case. Hard to know. Okay. So, Ms. Smith, good morning.
Good morning.
Let's do bench warrants for Mr. Jones on positions 1 and 2. But Ms. Rios, if you make contact with him, he can come on in. We'll handle it that way. Benjamin Sawyers should be in custody, and that would be your case, Ms. Wood?
Yes, Judge, good morning.
Good morning.
It'll be a waiver today.
All right. But we'll bring him out. We can chat briefly. Are any of the defendants up?
Everyone go.
Okay, except for Mr. Wright?
Mr. Wright.
Okay. All right, we'll handle that. Ms. Smith, do we need to wait on Mr. Abate to get here to just do the waiver of arraignment, or are you okay if we handle that?
I'm okay to handle it and I'll just let him know.
Yeah. Okay. Charles Blunt or Blount?
Your Honor, he will be mine. I think I filed a waiver in his case.
Okay, well, he's here, so we'll bring him out. Ms. Nix is on the call. Do you need her to stick around? Is this one that you want to talk with her about or talk with Mr. Blount about, or we'll just bring him out to do the greetings?
I think we'll just need to bring him out to do that. Actually, I think we can hold him because I think I do have an offer for him to see if he wants to resolve today.
Okay, all right, we'll hold on to him.
Good morning.
Hello, Ms. Gordon.
Hello. And Cameron Wright, I heard you ask about bringing him up. He is not in custody. He is on the Zoom. I understand there may be a probation warrant, but he has not been picked up on that. So he is on Zoom.
Got it. Well, maybe there are two Cameron Wrights. I hope that Cameron Wright, you and I know, is the one who's on Zoom. But Deputy Gordon is being told that there's a Cameron Wright in, you think he's live streaming from the basement of the courthouse?
I don't think so, Judge.
No? Okay. Well, great. Well, we're going to get to him in a little bit in the calendar, and we can navigate what we need to navigate because there is a warrant. All right. We'll bring Mr. Blunt out later. You'll talk with him, Ms. Rios, maybe when we take a break. See if that's resolvable. So Ms. Nix, if you don't mind staying on the Zoom for a little while. Leslie Cook.
He will be mine, Judge. I think he's in custody.
He is.
I need to speak with him. He's got a bunch of unindicted cases that we're gonna try to wrap up together in a global resolution.
Okay.
So I think this will probably just be a waiver today, but we are working towards pleas.
Okay. Are his unindicted cases like the indicted one?
It's all similar.
Second degree burglary type things? Okay. Well,
I have a note that I guess it's different this morning.
It was Ania's.
Was there a drug program?
There was, yeah, but he didn't get accepted. Mhm.
okay. So we'll bring him out and I'll explain that we're going to try to get all his moving parts into one space. Did you do or you will do a waiver on this one?
I haven't done it yet, but I will do it.
Okay. All right. Lefabian Kims.
I believe I filed a bond motion on that case.
You did. Is Cheyenne Nagasaka a colleague of yours?
Yes.
Okay. So your case now, and Ms. Smith will talk about bond. Ms. Willingham will talk about bond this morning. All right. Tayshawn Lilly.
If you mind, I got a waiver. I think he was excused. Miss Willingham and I are working on this one, but it's not resolving today.
Okay, and he's not, I have a booking number listed.
He's out.
He's out? Okay. All right, so this is one where we won't see him. He was excused. So we'll do a scheduling order. That. Okay. Cameron Wright is on the call. We'll have that conversation in a moment. Withum Kimble. I don't have a lawyer. I have Ms. Smith listed, but I don't have a defense attorney. Let's look. Stacy, oops, that's not the right case.
Oh,
Stacy Levy.
so well. Judge, if we could come back to this one.
Yeah, we will. I'm just trying to track down all the, so you have a conflict. Ms. Rios took the plea on Ms. Hayes, a co-defendant. So we will need to get Mr. Kimble, a
Okay.
conflict.
Okay.
They should be assigned.
I'll double check.
Yeah, he was assigned, I think.
Okay.
Says he was arrested on a grand jury warrant. Mystery. Okay.
I can provide some context on that, Judge. I'll be in the courtroom in a little while.
Oh, okay. How are you familiar with the Kimble case?
Judge, this is a case that I did a proffer on a case and received some information from a co-defendant and then issued a grand jury warrant based on that. The information.
Got it. Okay. All right. Well, Mr. Kimble is in custody and we'll at least bring him out and I can explain we need to get him a lawyer. But that's what we'll do today. Thank you. Ray Chisum. So Ms. Rios, you represent the co-defendant who didn't show up for final plea, I guess? Yeah, just last month. So we need to get a lawyer for Mr. Chisum. And then we've got a series of revocations. I have Leslie Cook down. I have a probation warrant for him, but he's not on for revocation. Oh, he's 15. Is that the same Leslie Cook? Are we gonna hold off on the revocation and just bring everything together? Okay,
Yes.
that makes sense. It seemed like I skimmed the warrants this morning and most of them seemed pretty resolvable. They were technical, except for Mr. Cody. But then I'll note he only has 8 months and 12 days left. So I see a pretty easy resolution there, but we'll see how that plays out. Because the other, Charles Massie, I can't quite tell what's going on. He was in Texas, got extradited from Texas. So we may have to work through that one a little bit, but the others I think shouldn't be super complicated.
To talk to Slade and what of the revocation doesn't get talk to Tobias Slade.
Okay. I'm wondering if I was missing one warrant. I don't have anything for Alton Jordan. Okay, I'll find it in my email. All right. Let me see if he goes on the Cody list or the other list.
Ms. Simpson, did we hear back from Ms. Ward?
Did not,
So for Mr. Jordan, we were trying to get him back into drug court. Or he wasn't supposed to go, but then he picked up on something, so they ended up being able to go. And we reached out to Ms. Ward and she said she was supposed to be interviewing him, was it yesterday?
yeah, but the staff that was supposed to interview was already at the jail, and so she was supposed to update us once they were able to connect back.
Okay, but the goal would be to get Mr. Jordan into drug court. Did you say he was earlier?
He was originally sentenced to drug court, in addition to a condition of his sentence also completing weekend jail. And the basis of the warrant is he didn't complete weekend jail.
Oh.
It was supposed to be, if I remember correctly, 16 weekends. And
Oh yeah, 16 weekends, but then he also picked up a shoplifting in Clayton County.
charge is still pending, it's unindicted still.
Okay, but that's a misdemeanor. That shouldn't keep him out of drug court. It's that one of the issues is he didn't go into drug court.
Yes, and so because between the weekend, it's been a weekend there and I'm picking up the charge, he didn't make it to go to orientation.
Okay, so they need to talk to him, but if he had already been admitted into drug court, this should be a pretty easy readmit.
I don't know if the interview actually took place.
Okay,
He's saying it did, so I don't know, I spoke to him and he's saying it did, but then he just didn't get to show up because he was picked up on the other case. So, I don't know.
okay.
I don't know if we need to reset it for like a week.
Well, we'll chat with him, but maybe you guys could shoot Ms. Ward an email saying, do you have any update on Alton Jordan? See what she has to say. And then we just may have to bump it if they say we need to talk to him again. All right, let's talk about Cameron Wright, and then we will get back to the top of the calendar. Is there anyone in here who didn't hear their name called, or you're here for other folks?
Mr. Simpson is early.
Okay, great. You're here for this afternoon. Okay, stay comfortable. Ma'am, you're here for a name that I called? Yes.
Sawyers.
Okay, great. That's what we're going to do second. But we're going to do Cameron Wright first.
And
So,
if we could actually, so Miss Singleton was going to sign on for this. I know that she's not, she's no longer representing, she's no longer supervising Cameron, but because she did for a long time and knows him and his family and his situation, I think the best of anyone, I would like her to be present when we discuss him.
okay.
She should be on very shortly.
Then we'll hold off, and if you want to send a chat or just kind of barge in verbally once she's on, I may not notice right away. We'll certainly, once she's on, so we don't keep you all waiting, we'll pivot to that. Thank you.
Thank you, Judge.
Okay. Deputy Gordon, you need another person? Okay.
Or
Maybe so. Did the little button is, yeah, right there. It's like right under the word bang. It should say Bang and Olufsen. Yeah. Not back there?
she's not that problem.
Okay. We're going to start with Mr. Sawyers. Good morning. You are?
That's the afternoon calendar
All right.
as well, Judge.
Well, we may be able to tackle some of those this morning. We've got people here. Hey, Mr. Sawyers, come on up to the podium, please. Good morning.
Good morning.
I'm Judge McBurney. Your case has been assigned to my division, and today is your arraignment date, although Ms. Wood, working hard on your behalf, has already filed a waiver of arraignment, meaning she's entered a plea of not guilty for you, told the state she wants discovery on your on your behalf. All that. But I wanted you, since you were brought over, to come on out so you could meet me, I could meet you, and I could let you know what's happening with your case. The prosecutor in your case, Mr. Body, is here in court. He will get discovery to Ms. Wood. It'll be police reports. There may be video. There's something about a camera because they were able to do some math and allege that you were going 91 miles an hour. But they're going to get all that material to your lawyer. She'll meet with you and talk with you about next steps. Are we going to file motions? Are we going to argue for a lower bond? Are we going to do this or that? And I'll get you back in here once you guys have made some of those decisions. My goal is to keep the case moving. I know you've been in jail for a while, serious charges, and we need to sort all this out. So that's what's happening next. Do you have any questions about any of that?
No, sir.
Okay. Ms. Wood, anything else on behalf of Mr. Sawyers?
No, Your Honor, thank you.
Mr. Body, anything you're aware of that's going to make discovery slow moving from your side?
No, yeah, everything I'll get served to Ms. Wood today or tomorrow. Not Ms. Voluminous is the, I call it black box, but that's how everything's going on.
Okay. So all that'll get to your lawyer and you guys will go from there. And I'll see you soon. Okay. Thanks, Ms. Wood. Yes, sir.
And Your Honor, Miss Singleton is on now if you want to handle Cameron Wright.
We'll do that. Hey, Mr. Wright, can you turn your camera on, please? All right, you got some pretty serious lighting going on there. So Mr. Wright, good morning. We need to talk a little bit about what's been going on. Ms. Hold on, let me see if I've got the document here. So, Mr. Wright, we got a little nervous in that we couldn't track you down. I think I may even have signed a warrant in connection with that. In February, your probation officer went to what was supposed to be your address of record, and they couldn't find you. used the phone number they had, couldn't find you. You didn't show up for intake. This would be you as an adult, meaning now that you're 17. So I'm going to ask Ms. Gordon and Ms. Singleton to give me a little bit of update about what's going on and how best we can connect you with probation, because they need to be a part of your life now that Ms. Singleton has had to step back. So Ms. Gordon, why don't you get us started and then we'll move forward.
Yeah, thank you, Your Honor. So Cameron, I believe, is currently at his grandmother's house. As I think the court knows from our prior status check-in hearings on this case, his life living at home with mom was and continues to be quite chaotic and I would say traumatic for Cameron. Cameron started, this case started when he was a very young teen, I believe 13, maybe 14. He is now 17, but he is still a child who relies on his parents for a lot, including transportation and things like that. So I understand that he has failed to properly report since his case has transitioned from Miss Singleton to felony probation. But I don't think that is for lack of trying on Cameron's part. I don't think it is per se his fault that he has not reported. I'll let Miss Singleton give a little bit more detail because she has had more contact with the family over time than I have. So I'll let her kind of take it from there and give the court a little bit more information.
Okay. Good morning, Ms. Singleton.
Good morning, Your Honor. Can you hear me?
Yes, ma'am.
Okay. So I believe that the last court date we might have had was in February. I'm sorry, I don't have it in front of me. But once we had the hearing where it was made apparent to the court that he was going to transition over to DOC, I did speak with probation and get the appointment information, address, phone number, everything that was needed, and I forwarded all that information to his mother. When we had the last court date, he had not appeared for that appointment, and Your Honor, the case was rescheduled. There was a little difficulty with getting in touch with Cameron that morning, but I was able to get in touch with him. And he was given a second appointment, which I believe was possibly the 19th. But in any case, I sent his mother another text message repeating the same information as far as date. The date that he needed to now report, the time, the location, spoke with probation, make sure everything was in place, and encouraged her to please contact me if there were any issues, just to make sure that he didn't have another problem. I then spoke with probation in Your Honor's courtroom a few weeks ago and was told that he did not report and that they were not able to, that they did field visits, but he was not able to be located. And I guess at that point, maybe the court issued a warrant. The court is aware that when Cameron was at the Promise Center, when he was participating in programming there, he was doing quite well. That was under the supervision of his grandmother. He was living with her. When everything fell apart and he went back to live with his mother, it appeared that it would be I was hopeful because things seem to have settled, but we are back in the same situation that the case was in at the time that he first got placed on the compliance calendars, Your Honor. I was able to reach out to different family members this morning and locate him today visiting at his grandmother's right now. That's where we are, Your Honor. My understanding, I went by the school that I thought he was supposed to be going to, which is the Perry Learning Center. I was there about a week and a half ago. They said that he never appeared. He did tell me this morning that he went to the GED program on this past Monday. I'm not sure if he's saying yesterday or a week ago, but that's the information that I have at this point, Your Honor.
And Judge, I do just want to clarify that when Miss Singleton says that things fell apart with grandmother, that wasn't because of Cameron doing anything wrong or messing up. Things fell apart with his grandmother because of his mother's behavior when all of that sort of drama unfolded at the At Promise Center with mom going up there and getting into a fight. And his grandmother and his father at that point were angry and upset with Cameron's mother. And that prompted them to say, I'm not going to deal with this anymore. And Cameron at that point went back to live with his mother, which is when, things sort of started to fall apart for him as well. So I think what has been made clear to me and hopefully to the court is that when Cameron is in a calm and stable living environment, which he was with his grandmother, he has the ability and the capacity to succeed because he was going to school, he was excelling in school, he was doing his work, he was doing well, and he had a calm and stable and supportive home to go back to at the end of his days. Now that he is back with his mother because his other family members have said, I can't deal with the mother, and so I can't have Cameron here. When he's with his mother, that is when things don't get done. And I think that he has shown, and the situation has shown that things not getting done is not attributable to Cameron himself, but to his mother. This is part of the general problem with, in my view, charging and convicting young people, children in superior court, because we are saying that you are held accountable for this, but they can't be held fully accountable because they are still children and because they must still rely on the adults in their life, not only for things like transportation and signing of documents, but for the stability and the emotional support that they need in order to succeed.
I hear you, and I don't disagree with any of that, other than there is some role for Cameron to play in this process of being accountable and showing up. I don't know what his access is to a phone or to email, but Cameron, Mr. Wright, you're going to need to communicate better with probation. Ms. Singleton is no longer the person who is supervising you, but it's someone from the Department of Community Supervision, also known as probation. And you need to make that connection and you need to maintain that connection. And I don't think that's something that is too burdensome for a 17-year-old. Even if you don't have your own phone, you borrow someone's phone to stay in touch with probation. But that is, to me, a pretty minimal obligation that flows naturally from the responsibility you agreed to take on when you and Ms. Gordon negotiated the very favorable outcome to this case that involves some pretty serious charges. So I'm very sympathetic to the chaos created by a wayward parent. That is not your fault. But there's a certain bit of ownership, even as a 17-year-old, you need to take on in this process. And I think that's what this conversation is about. And that's really what's been frustrating for probation, because they can't even make that initial connection with you. Where are you staying these days? We can't hear you. I don't know. It doesn't say you're on mute, but we can't hear what you're saying. We can see you, but we can't hear you. Still no luck. You want to drop off and get back on? Okay. Ms. Simpson, if we can figure out a way for Mr. Wright to connect with, I think it's Officer Brown who was trying to work with him. Is that going to be a he calls Officer Brown, or does he need to, I don't know how transportation works for him. That may be more complicated than just getting on the phone.
He can
Hey.
call us.
Hey,
He really needs to come in.
yep,
Because we have no paperwork on.
you got nothing.
We have.
Okay. Mr. Wright, can you hear us? Oh, he disappeared again. That's too bad. He was on. Mr. Wright, you there?
Yeah, I'm here. Can y'all hear me?
Kinda. Why don't you not worry about the video? You can turn the video off, so we'll just focus on audio.
Okay, can y'all hear? You can hear me?
Yeah, so just stay where you are. Don't move around. Where are you
Okay.
staying these days?
I'm staying with my mother, but it's like with my mother, I had to worry about like a problem. Like I had to worry about I had to worry about being on her good side or her bad side, waking up or just with through anything. Like if stuff not going her way, like like the whole day can be going left. Like it can go left. Like just by off her don't like off her like not being in a good mood. So I feel like that wouldn't even be good for me going like doing this like my probation stuff over there with her, because like if anything like she can get mad right now like and just call my probation officer or do anything to get me in trouble like she do that my grandma or my dad would not do, because
Okay,
like she like as I don't say it, but she have anger problems, so it's no working, like it's no working with her. Like she can be cool one moment and then it take just one little piece and you could tick her all the way off, and the whole day would just go left for
got
from
it.
the rest
Okay.
on
No, I understand, and I'm sorry you're having to deal with that. Are you at your grandmother's right now?
right now currently, yes.
Okay. How do you get to your grandmother's from your mom's?
I rode the bus, the
Okay.
MARTA.
Does your mom let you, I mean, does your grandmother let you stay there, or she only lets you visit and you got to go home?
I mean, she like when stuff like this happen, like if me and my mom have a disagreement, she'll let me come over here for a couple days so it won't escalate, because she know how my mother gets, so she know like it'll go on and on and on if she don't get her peace. So
Yep.
she let me come over here for a couple days or weeks until like me and my mother get back on the right time, like the right term.
Understood. And what about your father? Are you able to stay with him?
He stay with my grandma, like they stay in the same house, but he work out of town, so he really don't be here like that. Like he out of town now working.
Got it. So when you are at your grandmother's, you're also at your father's. It's the same place.
Yeah, it's the same place, yes, sir.
Okay. Well, life remains complicated for you. You need to get to the probation office. They don't have any information on you other than a warrant that I've signed. And I'm willing to set aside that warrant if you can figure out a way. If you took the bus to your grandma's, you could take the bus to, go
To the
ahead.
probation. Yeah,
Yeah,
cause they don't have no type of like how they came the first time to the house. Cause I never knew they came. They showed up to any house for me, or I never got text or call. I never known. But
well, they might not have the right number for you. That's the problem. And that's what Miss Simpson, who's here in court, who's with probation, is urging, that if you go down to the probation office, then you can meet with someone and say, here's all my info, here's my grandma's info, here's my dad's info, so that probation can track you down when they need to and make sure you're doing okay. So I need you at some point this week, to get to the probation office. Do you know where that is?
no, I'm not sure. I don't remember. I don't.
Okay, how do we get you information about where you need to go?
I
If
have
we,
a I have a new number that y'all contact me from.
okay, so why don't you give us that number? I'm going to ask Ms. Gordon to text you the information about where to go for probation. It's real near the courthouse, so you've been close to it before. It's on Memorial Drive, like 2 blocks from the courthouse, but we'll give you the specific address, and you need to go there this week. What's the phone number we should be using for you?
Okay, 470-465-3845.
3845. All right. Let me tell you how this is going to work. Ms. Gordon's going to send you this information. I need to hear from probation that you made it to the office sometime this week. It's Tuesday at 9:45. I'm going to check with Ms. Simpson at the end of the week. And if the answer is Mr. Wright did not go to the probation office, then I'm going to put that warrant back in place. And I don't say that to threaten you. I'm not trying to be difficult, but we got to get you plugged into probation.
I know.
The other way to do it is just to scoop you up, but that's the worst way to do it.
Yes.
Cameron,
Because I don't want to get screwed.
Cameron,
Okay.
can you repeat that phone number one more time, Cameron?
470-465-3845.
Mm-hmm. Okay, I'm gonna text you.
Okay.
And I'm gonna let you go once you tell me you got Ms. Gordon's text, because then we'll know there's a line of communication. I'm gonna get that phone number to probation as well. You got it? Okay, probation's got that number, so they might text you as well saying, remember, you need to come down here. Your officer, the person you'll be working with, it's changed already.
What's changed?
Hold on.
Brown, she's kind of, did the warrant.
She said, I'm done. Okay, so who's the new person?
Officer Warner's WARNER.
Is there only one Warner, or do we need to know? Okay, so your probation officer's last name is Warner, WARNER, Officer Warner. And
Officer Warner.
ideally, that's who you'd meet with when you go to the office, but is that a he or a she? She may not be there. That's not your problem. If she's not there, you still are going to say, hey, I'm Cameron Wright. I've got this case. I'm on probation. And they're going to get all your info and maybe give you some info, with the goal being that you and Officer Warner can connect and start having conversations about whether you're doing okay and getting the support you need. Okay?
And
Okay.
Your Honor, can someone please provide me with that probation office address?
Yeah, we'll get that to you before you get off the call. Ms. Singleton, anything more from you?
No, Your Honor.
Okay, thank you again for reminding me about some of the complications in this situation. I appreciate you dialing in.
Thank you, Your Honor. Y'all have a good day.
You too. Ms. Simpson, what's the address that Ms. Gordon should send to Mr. Wright?
276 Memorial Drive,
276 Memorial Drive,
Atlanta, Georgia,
ATL 30303. That's how close it is to the courthouse, same zip code, 30303. So Mr. Wright, Ms. Gordon's going to send you that address. There are buses that get you there. Worst case scenario, you take the train to Garnett and then you just walk. But sometime this week, by Friday, you need to show up there. And if you show up and like, who are you? We don't know what's going on. Call Ms. Gordon and say, wait, I'm now at probation and they're trying to turn me away. I don't mean for that to happen. And she can reach out and we'll figure it out. Okay.
Okay.
Do you have questions about anything?
Yeah, I had one question. I was wondering, like, if they was like, if I didn't have no way to them sometimes, would they be able to still come like out to me? Sometimes?
Yes. Once you have a good phone number for your officer.
Okay.
Oh, don't come on Friday. Friday's Good Friday, and the probation office is closed. So you got to go there today, tomorrow, or Thursday. Do not wait till Friday. Okay.
Okay.
So if you're in a safe space right now with your grandmother and whatnot, you may want to take advantage of this day to figure out a way to get there. But to answer your question, once you and Officer Warner connect and get to know each other, then she may say, hey, we need to meet. You can say, great, could we meet at the Wendy's on wherever? It doesn't need to be at your mom's place. In fact, you can help her understand that, hey, if you just show up and bang on my mom's door, that may make things real complicated for everyone. So Officer Warner is not interested in making your life more complicated. She's wanting to make sure that you are doing things to make it less complicated. Okay?
Yes, sir.
So it could be, hey, when we meet, we need to do it at my grandmother's house or somewhere else, or who knows. But just, you got to connect with Officer Warner, and that process starts by you going to that address on Memorial Drive. Okay?
Yes, sir.
Any other questions?
No, man. I mean, no, sir.
Cameron,
I'm sorry.
Cameron, I just sent you 3 text messages. Can you confirm that you received them at that number?
Yes, maybe.
Did you get the text messages? We lost your audio.
No. I'll call him, Judge, and make sure he got him.
Okay, and Ms. Simpson sent one as well, so just make sure from him that he got the one from Ms. Simpson as well.
I will.
Okay? All right, thank you for connecting us with Mr. Wright.
Thank you, Your Honor.
All right, goodbye, Mr. Wright.
May I be excused?
Yes, ma'am.
Thank you.
Okay. Ms. Rios isn't here, so should we bring Mr. Cook out?
Yes, Judge.
Deputy Gordon, can we bring Mr. Cook out, please? Right up to the podium, Mr. Cook. You stand in front of the screen there. Good morning.
Good morning.
How are you?
I'm hanging in there.
Hanging in there is good. You've been in jail for a minute, and Ms. Wood is working to get you out, but you have a bunch of business. So, Mr. Cook, you're here today for a couple things, but really we're just going to talk about them because Ms. Wood needs to take a few more steps before I think we'll be in a position to hopefully get you into drug court. No, take a global plea.
Yes.
I'm confusing 2 cases.
Rejected him, Judge.
Okay, so Mr. Cook, you have new charges. That's one reason why you're here. And Ms. Wood has filed a waiver of arraignment, meaning she's entered a plea of not guilty for you. It's a 2nd-degree burglary, the usual thing. You also have a revocation that's based on these new charges and other new charges for a bunch of old burglaries in the 2nd degree. And what Ms. Wood is working on with the prosecutor on all your stuff, that's Ms. Smith, is to see if there can be a global resolution that'll take care of the revocation and this new indictment and what may be a few other, they may be what we call accusations, where everyone agrees, look, Mr. Cook's going to be pleading guilty to these other 2nd-degree burglaries, but let's wrap it all into one thing rather than we do a revocation for, I'm making numbers up, 6 months, and then you take a plea for 3 months and this and that. Just do everything at once. That makes a ton of sense, but it also takes a little bit of time. And so Ms. Wood has asked me to hold off on the revocation, handle today's arraignment, which we're doing, and then we're going to agree on a time to put you on another calendar that provides Ms. Wood enough leeway that by then she'll have negotiated with the prosecutor. And when you come back, it'll be, let's resolve all these things. And there's not something hanging so that when we think we're done, just as you're ready to go, you get pulled back in.
Yes, sir.
Does that make sense?
That's a lot.
Okay. Ms. Wood, anything you want to add about Mr. Cook's situation?
No, Your Honor.
So we've got new indictment, revocation, and then some unindicted cases that we're going to corral.
Yes.
Okay. Ms. Smith, anything from the state?
Nothing, Your Honor.
Are you able to nudge your charging people to focus on Mr. Cook's uncharged cases?
Yes. I'll do
Great.
as much nudging as possible.
Okay,
And I'll get waivers in on those, so that will be helpful, I think.
sure. How many other cases are there?
You.
Okay, Mr. Cook, all right. We'll figure out when we can get you back here, but the goal next time you're here will be to have that conversation about resolutions rather than, hey, I'll see you in a few weeks, because one thing I know, while you are where you are, there won't be more second-degree burglaries. You're just going to be earning good time. You get credit for all this time you're in. So while the prosecutor's thinking, well, gosh, all these cases, you might need to do X, each day you are where you are, you're earning towards that number. Do you have questions about anything we discussed?
No, sir. One good thing. I was accepted to Must Ministries, which is a very structured program. It's an 18-month program.
Fantastic.
And I would really like to go there instead of other avenue.
Okay. It's what ministries?
Must Ministry.
MUST?
Yes, sir.
How'd you get in?
To a lot of prayer.
Okay. But like, how do you apply while you're in
They
custody?
went through one of your lawyers here, and I went through all the process, and it was like a 7-month process.
Great. And you were accepted.
Yes, I have the letter.
Well, I trust you, but the letter's a good thing to have. Do they wait on you? Because we're not going to get you back here tomorrow. It's going to
Yes,
take a
they-
little while.
They do.
Okay. And where is Must Ministries?
Sonoya, it's about an hour from here.
Okay. Maybe it's a slightly different name now, but I know people go to Sonoya and good things can happen. So good to know. Maybe Ms. Wood will factor that into what she recommends when we get to that point. Okay.
Yes, sir.
All right. I will see you soon.
All right, I appreciate you.
Thank you, Judge.
You're welcome. Ms. Smith, do you feel like you have all the PI numbers in connection with Mr. Cook?
Yeah.
I don't have any listed here. You don't need to share them with me. I just want to make sure if you do all this great work and come back and say, look, 4 accusations. And Ms. Wood said, yeah, but they're 5.
Yes, I think I have all of them, and then I'll just confirm with Ms. Wood also, so
Okay.
we're on the same page.
Great. Next up is Mr. Kims. Are you ready to do the bond hearing? Or,
Judge, the state would be asking for a continuance. I can move forward if necessary, but we have been trying to get in touch with our victim and have not been able to notify her of the hearing. I have made some substantial effort, so if the court is inclined to have us move forward today, I can still go through the defendant's criminal history. But I would ask for a short reset to be able to try and get in touch with her.
so it's not that you didn't know it was going to be a bond hearing. It's that you've tried, your team has tried your best to get in touch with the complaining witness in the case and have been unsuccessful.
Yes.
That's Natanya Smith?
Yes.
Okay. So since we're all here, I'm inclined to hear from both sides, and you'll be able to share what you can. And if you learn something because Ms. Smith surfaces, no reason you can't just shoot an email to me and Ms. Rio saying Ms. Smith steadfastly opposes a bond reduction, or as long as there's no violent conduct, whatever her perspective is on that.
Yes.
Okay? Ms. Rios, are you ready? Or do you want to wait till they track down Ms. Smith?
Is it this one? Are we talking?
Oh, Miss Gary.
Okay. All right. So if we could bring Lefabian Kims out.
rest of the bond hearing.
Good morning, Mr. Kims.
Hey, how you doing, buddy?
I'm okay. How are you?
Oh, I'm okay.
Good. Mr. Kims, I'm Judge McBurney, and we are doing a couple things today. It's your arraignment day on your case. Ms. Rios, who has been doing a bunch of work on your case and has filed some things, she's already filed a waiver of arraignment, meaning she's entered a plea of not guilty for you. That means the prosecution's going to get discovery to her so she can talk to you about what evidence the state has. Ms. Rios has also filed a motion for a bond reduction, and that's what we're going to do. Since she's waived arraignment, I don't have to talk to you about the charges you face, although it may come up a little bit in the conversation we have about bond. But what we're definitely going to talk about is whether your bond should be reduced from what it's at now, and if it's going to be reduced, what's that going to look like? So we're going to get on the record in your case. This is 26 SC 000-598, State versus Kims. Mr. Kims is in court with Ms. Rios, his attorney. Ms. Willingham represents the state. And Mr. Kims, you were given a bond in September of last year, a $14,000 bond. But I don't know that, part of what I would need to do, you don't have a bond at all on the kidnapping count. That's maybe part of the confusion. I don't know if Mr. Kims has tried to post the bond, but the bond he got in September, the kidnapping was dismissed, so maybe it was in connection.
Boston prison.
Okay, well, whatever it was supposed to be, what it is officially in the indictment is kidnapping. And you don't have a bond on that. You've got a bond for some other counts, but the bond and the indictment don't line up. So it may be that he shows in the system as no bond on something, but we'll address all that today. So it's $14,000 spread across some counts that some of which you don't face anymore. So let's work through all that. I'm going to hear from your lawyer. I'm also going to hear from the prosecutor. The prosecutor has asked for a little more time to see if Ms. Willingham, can get input from Ms. Smith. That's the person that you allegedly did these things to. We'll see what happens. Ms. Rios.
Yes, Your Honor. Mr. Kims is 47 years old. He's lived in Georgia for the last 7 years. Prior to being arrested, he was working at McDonald's as an overnight cook and a driver. He did graduate from high school, and he has 2 boys and 2 girls, ages 22, 20, 12, and 14. And he's an active father in all of their lives. He's been in custody for about a year now, and he's not able to make his bond. I think separate from the issue of him not having a bond on that case, that the bond is just too high for him to be able to afford. I do understand the nature of these charges, but again, at this point, they're allegations, and he's maintaining that this does not would happen the way the state is alleging that it happened, especially the kidnapping. Since she did come to his location, that's the extent I'll probably get into with the facts. But I'm asking for the bond to be reduced to $5,000, and I understand that's low, but that's the most he would be able to hope to make.
Okay. And you don't think there's anything else holding Mr. Kims? No holds from other places? I don't see anything in the system. Okay. Tell me your understanding of the connection Mr. Kims has to Ms. Smith. Is this a stranger, ex-girlfriend? Not the mother of any of the 4 kids?
No, Your Honor.
Okay. All right. And Mr. Kims, where did you live? Ms. Rios said you've been in Georgia for 7 years.
It's kind of what backwards. I've been here since I was 7 years old.
Okay. So you've been here for 40 years.
Yeah.
Sorry.
Got it. That's okay. She got her wires crossed. All right. So you've been here for a while.
Yeah.
Got it. Okay. Anything else at this point you want to add, Ms. Rios?
No, Your Honor.
All right. Ms. Willingham.
Yes, Judge.
I was gonna address the length of time that the defendant has been here, because he has a lengthy history for the time that he's been here in Georgia.
Yeah, I'm just looking through the local jailings and we go all the way back to 96.
That is correct, Your Honor. With most of the cases early on being, simple batteries, but even in addition to those misdemeanor charges from the 90s, the defendant had an FTA in 1998. He had a violation of controlled substance in 2001, a probation violation in 2002, another one in 2005. Somehow he got a first offender for a drug charge in 2013, but that was discharged. It was successfully discharged. Not quite sure how the first offender happened though. And then when this incident occurred, he actually was under a sentence of 10 years to serve 2 years with 5 of those years suspended. He was sentenced in that case, and that was a drug charge. He was sentenced in that case on May 22nd of 2022. So our case would have actually happened during the time that he was still under sentence. And that case includes a aggravated assault. So the defendant has quite a lengthy history that includes violent acts.
Do you have the indictment number for that?
It is 20 SC 174292.
Okay.
It is not the same victim, but I would have some serious concerns about the defendant's risk to reoffend. As we stand here today, it's been a pretty consistent history, with not many breaks. Oftentimes when we see cases where there's an old history, there's some kind of break. Here, it's pretty consistent from 1996 all the way up to present day, with the defendant having pretty consistent charges, and several violent offenses. So the state would argue that the defendant is a risk to reoffend. And as I've already mentioned, we have not, had direct communication with our victim, and that would also be a concern of ours if the defendant was released.
Okay. Mr. Kims, I didn't remember it, but your case from 2020 actually was a plea in front of me. You had Mr. Franklin as your lawyer and Ms. Hall was the prosecutor. You shot at someone.
Can I speak?
You're gonna get a chance to talk in just a minute, but you may want to preview to Ms. Rios what it is you're going to talk about. 5 to serve 2 years plus some probation. Okay. Okay.
And I'm sorry, Judge, I do want to add, he also has a simple battery out of Louisiana from 2015.
Okay. Does your file contain any input from Ms. Smith? I know recently you haven't been able to connect with her, but I'm curious if there are any notations of, hey, as long as he stays away, I'm okay, or the opposite.
No, Judge, I get all of our contact up until this point has been with her mother. I have spoken with her mom a couple of times, but I have not spoken with the victim directly.
Okay. And does her mom offer any perspective, sort of secondhand, as to what her daughter? Okay. Got it. Ms. Rios, your client had wanted to say something. Have you decided he shouldn't say something?
You're not gonna say anything?
No.
Okay. Anything you want to add?
No, Your Honor.
All right. So, Mr. Kims, I am, in light of reviewing the case you had a few years ago, concerned that something like this came up while you were on probation for that. And so I'm going to leave the bond as it is and let Ms. Rios continue doing work on your behalf. She's going to get discovery. Ms. Willingham, is there anything complicated about the discovery in this case? Any reason why you can't get it to Ms. Rios ASAP?
No.
Okay. So Ms. Rios is going to get the discovery in this case, which is going to be witness statements or body cam or whatever's out there. She'll review it. She'll talk to you about it. And then she's going to work with you on deciding what's the best way to move forward. let's get here for a trial. Is it going to be a plea? Is there something that needs to be suppressed because the police did something that Ms. Rios thinks wasn't the right way to do things during their investigation? She needs a chance to look at discovery and talk to you about it, and we'll take it from there. Okay?
Yes, sir.
All right. Thanks, Ms. Rios.
Okay.
And Judge, that concludes my visit for this morning.
Yes, if you don't have, we had a couple people who showed up early. Well,
Yeah,
we'll
good
just,
morning, Your Honor. I believe those are the family of Mr. Tony Cody.
no, we got a Mr. Stringer. You're Mr. Stringer? Yeah, is that your case, Ms. Willingham? No, Mr. Stringer is here, and remind me your name, sir? Yeah. Is it possibly Michael Simpson? Got it, same person. That's not you either. Okay, all right. So we'll see you this afternoon. All right, so Mr. Kimble is next. And Mr. Jerome, we are almost to your client.
All right.
So Ms. Wood, you didn't see anything in the system about your office having flagged that Mr. Kimble needs conflict counsel? I don't know how you guys know whether.
I sent the conflict.
Okay.
Right.
Well, I guess you would have done it because it's your case number.
Because I had, I sent it right after, and then I think I followed up and Mr. Haddad said it was through.
Okay. Are you Mr. Kimble?
Yes, sir.
Hey, I'm Judge McBurney. Nice to meet you. Mr. Kimble, you've been indicted for armed robbery and some other charges, picked up on a warrant. We need to get a lawyer for you because unless you're going to be hiring your own. I don't mean to presume that you're not bringing your own lawyer on board, but assuming you're not in a position to retain counsel, we need to get someone to represent you. The public defender who would normally step in and give you very able representation already represents a co-defendant in your case, so they can't represent you. You're entitled to conflict-free representation. Someone who's focused just on you, and the public defender's focused on a co-defendant. Are you planning on hiring a lawyer, or should I get one appointed to you?
Well, last time I came to court, that's what was told to me, that I was gonna get a lawyer appointed.
Okay, well, that's what we're gonna do. How long ago did you come to court?
I came on February the 20th. I've been here 4 months. I haven't
Gosh.
seen an attorney or talked to anyone about this case at all.
Okay, well, you and I are talking about it, but I'm not your lawyer. Let me see what's going on, because we need to bridge that gap and get you a lawyer. All right, so you may have been here on the 20th of February. That was the other time we had you on an inquiry calendar. And what should have flowed from there is getting a lawyer for you. But I will make sure today that we get the conflict defender's office focused on representing you. Let me check one thing, because there's a third defendant. I gotta make sure they're not already plugged in with that person. Nope, he's in the wind. Okay. So you need a lawyer. Okay. I apologize that this has taken a little bit, but we will get that fixed this week and have that lawyer connect with you. We'll need to bring you back so that we can handle your arraignment. Your lawyer will probably recommend waiving arraignment, but that's still a conversation we should all have. And I want to lay eyes on that lawyer so he or she can say, I've got Mr. Kimble and I'm handling this case. Okay?
Okay, when I talked to you last month, you had said you was gonna talk about my bond today.
So So we were, if you had a lawyer, we can't talk about bond without a lawyer on your behalf. And so I'm going to start making phone calls today because I thought this was being taken care of. And in fact, before you came out here, I pressed the public defender a bit and she showed me that she's actually made the inquiries that should have had the lawyer designated to represent you. So that lawyer, once we get him or her appointed, can very much talk about bond. And we'll do that, but we need to have that person in place, okay? Anything else?
No, sir. I just don't understand how why I'm having to be here this long without knowing anything about this situation.
So I'm happy to tell you what the indictment says. I can tell you what's in the indictment, but you should be frustrated, and I'm not offering excuses. I'm frustrated with you that a lawyer hasn't connected with you yet. That's what I want to fix. I can relieve your confusion a little bit by telling you what it says in the indictment, but your lawyer is the one who can give you the guidance of here's how it'll work with bond, here's the discovery, these are the police reports, that kind of stuff. So do you want me to tell you what's in the indictment?
Yes, sir.
Okay, let's do that. So, 2, 4, 5, 6. You are charged along with an Antonio Hayes and a Tanasia Hayes with the armed robbery of a guy named Charles Jenkins. And all this stuff that supposedly happened had it happened in February of 2022. And so you and the Hayeses supposedly took from Mr. Jenkins a cell phone, Visa debit cards, a gun, and a little over $600 in cash. You all committed an assault, an aggravated assault on Mr. Jenkins by pointing a gun at him. My guess is only one of you had a gun and pointed. It's usually not all three, but regardless, at least one of the three of you had a gun, pointed at Mr. Jenkins and said, "Give me your phone and your cards." Ms. Hayes alone is charged with going into this guy's truck. Mr. Jenkins had a Ford F-150, and she went in it. You and Mr. Hayes are charged with possessing a gun during commission of a felony. So maybe the story is there were two guns. You and Ms. Hayes are oddly on a different day, 6 days later, February 12th of 2022, you and Ms. Hayes are charged with shooting at a guy named Jonathan Voltaire. And then you're the only one charged in the last count, which is having a gun during this time when Mr. Voltaire got shot at. Those don't seem to be real connected to me, other than they're 6 days apart. This robbery of Mr. Jenkins and shooting at Mr. Voltaire. That's what's in the indictment. Don't talk about it. Don't say, I have no idea what it is, or, oh my gosh, you caught me. You and your lawyer are going to talk about it. And you're going to be able to tell your lawyer, I was in Texas in February of 2022, or whatever the situation might be. But you're certainly entitled to know what the allegations are. Those are the allegations. I'm going to get you that lawyer. He or she will come see you, and then we'll get you back here to do your arraignment, talk about bonds, and whatever else that lawyer and you want to talk about, okay?
Okay. About how long would I be looking at another court date?
Well, I want to move this one faster because what was supposed to happen between February 20th and now was that you would get that lawyer. So we would be talking today about bond, and you would already know what the charges are. So I'm going to try to have it happen in just a couple weeks and not I see you in a month, okay? But I'm going to get to work on it. I'm sorry that we brought you back here only for nothing to happen. That won't. When you are brought back next, it'll be because there is a lawyer in the mix, okay? I'll see you soon. Ms. Rios not here again, okay. Bounce forward. Ray Chisum. If we could bring him out, he's gonna want to know where his lawyer is. Give me 1 second, Mr. Chisholm. Good morning. I'm Judge McBurney, and you got picked up on a bench warrant in connection with these charges. We need to get you an attorney, unless you're planning on hiring an attorney. What's your?
Yeah, I need an attorney.
You need an attorney. The public defender already represents someone in your case, so I need to get a conflict defender appointed. Wasn't able to do that before we got you in here today. That was the hope, but it didn't happen. So what I'm going to do is get someone appointed to you this week. That lawyer will connect with you. Then we'll bring you back here and start moving your case forward, do the arraignment. If you want to talk about bond, they'll talk about bond, or at least setting aside the bench warrant, things like that. But we need to get that lawyer in place so he or she can be standing right next to you, advocating for you, okay? But I didn't want you to come over here and not come out, like, why'd you guys drag me over here? You have not been in custody for very long yet. I know it probably feels like a long time, but compared to the last guy, not long at all. And we weren't able to line that lawyer up during the couple weeks that you've been in, but we'll do that before we bring you back here next time to talk about moving the case forward. All right? You got any questions?
Can you tell me when I'm coming back to court?
Don't know for sure because I need to get that lawyer lined up and then check with that lawyer's schedule. But
no bond.
Pardon me?
Yeah, no bond.
Well, bond isn't the question so much as you missed court, and so there's a warrant. And so the discussion will be why you missed court. Maybe it was a bad address. Maybe you didn't know, whatever it is, but your lawyer needs to talk to you about it and then talk to me about it. And then we could look at whether I set aside the bench warrant because you already have a bond.
I do have a bond.
I think you do, but well.
Did I have a court? I mean, can you tell me what was my court date?
Sure. But before we dive into that, I want to let you know we're not fixing it today. You may say, "Oh, Judge, but you know what? I didn't know I had that court date." That may be true, and that's what your lawyer's gonna walk you through and then walk me through. So you had court in October of last year and didn't show. I signed a warrant and you got picked up, it looks like at the beginning of the month, on March 9th or thereabouts. You got indicted in August, had plea and arraignment in October, didn't show up for that, and that's the deal. But your bond, you got bond back in 2024.
Yeah, that's when I first got the case.
Right. So in theory, that bond is still there. I'll need to make sure it's there. If I decide to set aside the bench warrant, we'll need to make sure that there's still a bond in place, that it didn't get surrendered. But we'll do that once we get that lawyer appointed to represent you, okay? And we'll get you back here in a couple weeks. All right, Mr. Jerome, you ready for Tony Cody?
Yes, Your Honor. Hold on 1 second here.
Okay.
Apologize. Yes, Your Honor. So we have Tony Cody on the calendar. I was trying to reach out to the DA on this, but I I'm not sure. It seems like court is not going to be very long today. I was still anticipating coming up to Fulton County, but I'm not done in Cobb yet.
Okay, so a couple things. One, we are gonna wrap up here probably in the next half hour, but we have a second criminal calendar at 1, and Mr. Cody's in custody. So it would be fine if you want to be here for the afternoon calendar. We could talk about Mr. Cody then, if that works better for your schedule.
No, I also have some calendars this afternoon also.
Okay.
So it's fine. We'll arraign him. I'll call the DA, and if we are gonna work something out, I'll come this afternoon.
Okay.
If not, we'll just.
Well, and there's nothing to arraign. He's on for a revocation. He's got about 8 months left on probation, and the basis for the revocation are some new charges. They just haven't been indicted yet. He actually has 2 different sets of new charges, one from 25, one from 26. And right now, I think only one of them is the basis for the revocation. But as I was just thinking through where we're going here, given what the allegations are, probably makes sense for him to try to resolve everything together. I don't think this is going to be a time served type of revocation. But before you drive all the way down here, if you wanted a chance to negotiate some with Ms. Smith, who's here in court, I'm happy to bring Mr. Cody out right now to say, we're not going to resolve your case today, but Mr. Jerome is plugged in and he's going to meet with Ms. Smith, and then we can figure out a time to bring him back. You tell me what works best for you.
All right. Yes, and that's fine. We can do that. And essentially, whenever you put him back on the calendar, in all honesty, I think that Ms. Smith is pretty solid in her position, and this may be a stipulation and a hearing on the sentencing. And I'd rather be there in person if we are going to have a hearing on sentencing. So just let me know whenever the next available date is for that.
Okay, I agree with your approach to that. Let's bring Mr. Cody out so he can see you and you can see him, and we'll just have that conversation about resetting it, okay?
All right.
Okay, can we bring Mr. Cody out? Mr. Cody, come on up to the podium, please. Mr. Cody, I'm going to add your lawyer to the screen there so you can see him. Mr. Jerome is a busy man and is bouncing between courthouses, but he managed to plug in so we can talk for a quick second about where we're heading with your cases. You have a case for which you're on probation in my courtroom. You've got just under 9 months left, about 8.5 months left on that. I signed a probation warrant in December of last year, so about 3 months ago, that alleges that in December of last year, you got arrested for drugs and had a gun. So you've got these unindicted charges. You may have 2 sets of unindicted charges. This probation warrant. So you got a few irons in the fire. And what Mr. Jerome has asked is that he be given an opportunity to negotiate with the prosecutor who's handling all these pieces to see if there's a way to line everything up and knock it out all at once. I think that makes a ton of sense. So he needs a little time to do that. We're going to reset your revocation. And when you are back here, Mr. Jerome will be here in person, and we'll either just deal with the revocation or its potential. It may be that we handle the revocation, and if the state and you have agreed, it may be that the state goes ahead and accuses these unindicted things and you work out those charges as well. That is not required. My focus is on the revocation, and that's what I intend to deal with, but sometimes the lawyers are able to handle a little bit more. Do you have any questions about what I just discussed?
So you talking about putting my cases with the revocation?
So I'm not saying that that has to happen. I'm saying that often happens. If the basis for, I'm gonna make this up. You're on probation for drugs. You get arrested with drugs. Oftentimes, the defense attorney will say, hey, can we do the revocation and a plea to the new drugs all at once? Because the new case, when it gets indicted, is gonna go to some other judge. I might revoke you for 6 months. That judge may say, well, that wasn't my revocation. Here's a new drug case. I'm gonna give Mr. Cody a year. And you miss out on having everything sentenced all together. So Mr. Jerome may counsel you to try to have it all together, but he may not. And he may learn, you know what? The state's not gonna charge these new cases for a long time. And you and he may say, let's knock out this revocation. You don't have much probation left anyway. And so it may just be, let's revoke the balance and we'll deal with these other cases if and when they get charged. So I'm not dictating anything. I just was describing to you a potential scenario that may play out. What I know is that I'm bringing you back here in a few weeks to deal with the revocation. Mr. Jerome wants some time to press the prosecutor to see what he can arrange for you, and he wants to be able to be here in person for whatever hearing we have about that revocation. Okay?
All right.
Any other questions?
No.
Mr. Jerome, you'll be in touch with Mr. Cody soon?
Yes, Mr. Cody, I'll be in touch with you this week. I'll be in touch with you this week by Friday. All right, I'll come down to the jail.
All right. Thank you, Mr. Cody. I'll see you soon.
Yeah, and just to, Judge, if I just may say one thing here.
Sure.
All right, and so Mr. Cody, just so that you know, we didn't get a deal, and so that's why we're resetting this, all right?
All right.
Okay.
All right.
Sounds good.
All right, thank you, Judge. May I be excused?
Yes, sir.
All right.
Ms. Rios, do you want to do Mr. Jordan or do you want to, Ms. Nix is still here. Have you sorted something out with it? Is it Blount or Blunt?
Blunt.
Blunt.
And then,
Okay.
yes, we have a negotiated plea.
Do you want to do that?
Yeah.
Okay. Let's bring Mr. Blunt out, please. Deputy Gordon, the witness machine is doing its weird thing again. It says the camera's on, but it's not. I don't know what it says on the screen.
Preferred camera is not working. Please reconnect or restart camera. I didn't touch it this time.
Nope, no. It was, as you were walking up, I looked like, the camera's not on. It's probably, should I just disconnect it from Zoom and log it back in? Oh, you shut it down. Okay. Maybe that'll do it. All right, let me see if I can add it. Mr. Blunt, sorry, this is taking a minute. Appreciate your patience. It's not working. We will press on. Am I pronouncing it correctly? Is it Blunt?
Yes, sir.
Okay. Mr. Blunt, Ms. Rios tells me you're prepared to enter a plea in your case. Is that right?
Yes, sir.
Okay. We're going to get on the record in your case. It's 26 SC 000556. You're here in court with Ms. Rios. Ms. Nix, the prosecutor, is here as well, invisible. Mr. Blunt, in a moment, Ms. Nix is going to put you under oath and ask you a bunch of questions about your case and your rights. You need to answer those truthfully and completely. You also need to let me know if you have questions about anything we're discussing. Will you do that?
Yes.
Okay. Ms. Nix, when you're ready.
Yes. Mr. Blunt, please raise your right hand.
I can't.
Oh. Can you do
I'm
it?
handcuffed. I can't do anything.
That's fine. Just,
You can
Just put
raise
your
it
hand
to the
out.
best of your
yeah, there you
ability.
go. That'll do it.
Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Put your hand down. Please state your true, correct, and legal name.
Charles Allen Blunt.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
63.
How far have you gone in school?
I have a GED and some college.
Is English your native or dominant language?
Yes.
Do you understand that you've been charged with the following offense, state sex offender registry violation?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charge against you?
Yes.
Have you had the opportunity to review your rights with your attorney?
Yes.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the case with your attorney, Ms. Rios?
No.
Are you satisfied with her services?
Yes.
Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any and all defects in the indictment for purposes of the plea?
Yes.
Mr. Blunt, do you remember having been arrested on this charge?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? The state recommends a 5-year sentence to be probated.
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
You understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes.
You understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
You understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
You understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charge of state sex offender registry violation in indictment number 26 SC 000556?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that if you believe there is some error in your guilt, you can apply to the appropriate appellate court to request a discretionary appeal as outlined in OCGA 5-6-35 within 30 days of today?
Yes.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, and since this is a felony, you have only 4 years from today to do so.
Yes.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about November 25th, 2025 to December 8th, 2025, the defendant changed his address from 200 Edgewood Avenue, apartment 412, without updating his address with the Fulton County Sheriff's Office, as he is required to do as a registered sex offender due to a 2002 conviction for aggravated child molestation in Clayton County, and this occurred in Fulton County. Other than the underlying offense that requires him to register, he does have 3 other registry violations, 1 in Clayton County and 2 in Fulton. The most recent conviction is in 2019
For,
for the registration violation.
okay, so it's been 5-6 years since he's had an issue with registering. I don't quite understand. So sometime around Thanksgiving-ish last year, Mr. Blunt moved and just didn't update with the sheriff that he moved.
Yes, sir.
Okay.
That's when it was determined.
It was determined on December 8th that he hadn't registered.
Came in to do his updated registration and gave that same address in December. But a verification of his address was done in November and determined that he did not live there.
Got it. So there had been some change that he didn't sufficiently communicate.
Correct.
Okay. It wasn't birthday related. It was, I've moved. Or he was coming in for his birthday to update, to confirm, to renew, I guess, to say, hey, it's my annual renewal, but he gave an address where he didn't live anymore.
Correct.
Got it. Okay. Thank you. Ms. Stallworth?
Good morning, Your Honor.
Good morning. How are you?
I'm good. How are you?
I'm all right. How many cycles does Mr. Blunt have?
Yes, 27 total.
Okay. And Ms. Nix was saying she thinks the most recent conviction was a 2019 failure to register. Do you have that?
That's correct.
Okay. How many cycles since then?
I didn't see any since then, I don't believe. Let me double check. But I don't think that was the last not federal, felony conviction that I had.
Okay. Any cycles since 2019 other than you got arrested recent?
Checking. I'm checking. So the last cycle that I'm showing is 2017. Yeah, that one. That's the last cycle before this one that's on the calendar.
Got it. Thank you so much. Ms.
You're
Rios.
welcome.
Yes, Your Honor. Mr. Blunt is 63 years old. He has 4 children, 3 grown children and 1 4-year-old child. He's partially retired. He receives SSI, but also does contract work. I'm asking for a behavioral incident date of 1 year, considering that he hadn't had any issues with the registry and to waive probation fees. In regards to this case, he was homeless at the time, and he did come and let them know that he was homeless. And then they went to a different address and he wasn't there, but he had let them know that he was homeless. So I think that was the confusion. And so that's why I'm asking for him, just if he's done a good after a year, for him to be able to be off probation.
Okay. Mr. Blunt, do you have a place to stay now?
Yes, my son has told me that I could come stay with him. He lives in East Point. He moved there since I've been incarcerated, so I do not have the address.
Okay. I was going to say the 2 addresses that were in the system, I moved to a different case on the screen. It was like a Riverdale address, Shangri-La, something, and then.
But the Riverdale address was my mailing address only.
Okay. I'm focused more on where you're staying because, of course, because you have to register, there are limitations on where you can live. Is your son's house in East Point compliant with all the restrictions?
I have no restrictions. I can live and work anywhere.
Okay. I don't know how accurate that is, but as long as you believe you can stay at your son's house and that's not going to be an issue with probation, then that's good to know. Does your son work?
Yes.
What does he do?
He does security work for an apartment complex.
Okay. Who else is at his place?
My grandson stays there, and he may have a girlfriend that stays there from time to time.
He, meaning your son's girlfriend or your grandson's girlfriend? I don't know how old your grandson is.
My grandson is about 3.
Okay, probably not having a girlfriend over there.
I mean, he has a female friend that stays there.
Got it. Your son?
Yes.
Okay. And then his son is with him always, or he co-parents?
He co-parents.
Okay.
The son would probably, I think he told me the other day that the son would probably be going back to Texas to be with the mother in June.
Okay. Got it. Okay, so mom is out of state.
Yes.
Did your son let you know how long-term this residence is? Can you stay just for a week till you get on your feet, or you can be there for a while?
He didn't put a time limit on it.
Okay. All right. I'm not trying to pry into family business. Mostly I want to make sure you are set up for success. And being homeless and having to register is always complicated because you might think you got a stable address, then it's not so stable. And you're thinking, well, why do I need to update this address? Because it's not really address. It's where I'm staying tonight as opposed to for 3 weeks.
The address that he moved to, this is something that we was planning on doing before I got incarcerated, was to get a place.
Okay.
And I just happened to get incarcerated before he moved into the place. And so
Got it.
we was planning on staying together. So
And what were the circumstances of you getting picked up?
I got pulled over in Riverdale on my way home.
Okay. You got pulled over, they ran your name, and there was a warrant for you.
Yes.
Got it. Do you have a valid driver's license?
Not now. No, it's not valid now. And I need to pay it. I need to pay a reinstatement fee.
Okay. All right. Probably want to do that before you're driving again.
This is stuff that I thought was taken care of because I had been to court in Cobb County. That's where it was done. And I thought when I paid the fee in Cobb County that it would reinstate. Got
it. Didn't happen. Ms. Rios described you as semi-retired, but you do some contracting work?
Yes. I receive the SSI retirement thing, and I work part-time for on call as they need me for 2 different contract construction companies. One is Kite Construction, and the other is Moore Construction.
Okay. In a typical month, are you working 1 day a month or 3 weeks a month? What does it seem like?
In a typical month, I might work a total of like 15 days.
Okay, so sort of halftime.
Yeah.
All right. Thank you for sharing that. Do you have any questions about anything we discussed?
No, sir.
Okay, well, Mr. Blunt, I find there's a factual basis for your plea. You may feel frustrated by the way this played out, but really it's on you to make sure that the right address is in the system. And it sounds like maybe if the living arrangements with your son work out, you don't need to worry about changing things because it'll be that East Point address again and again. I also find that your plea is knowing and voluntary, meaning you've understood what we discussed and no one has forced you to enter this plea. Is that fair?
Yes, sir.
Okay. Ms. Rios, can someone in my office sign the indictment for you?
Yes, sir.
Ms. Nix, can we sign for you?
Yes, sir.
And Mr. Blunt, can someone in my office sign the indictment for you?
Yes.
Indicating your guilty plea.
Yes.
All right, we'll do that. Mr. Blunt, I am going to sentence you to 5 years to serve 2 months with the balance on probation. You'll get credit for the time you've already been in. I will set a behavioral incentive date of April 1, 2028. That's 2 years from now. If you have gone 2 years with no hiccups, with registering, driving on a suspended license or anything like that, probation can end early. And I will waive your probation supervision fees for the first 6 months. If after 6 months, you find that you are getting a fair amount of contracting work, then those probation supervision fees will kick in. But if for whatever reason you're not able to get a lot of work, then you and probation can talk about extending that fee waiver. I think that's it. Ms. Nix, anything else?
No, sir.
Ms. Rios, anything else?
Sure, thank you.
All right, Mr. Blunt, I hope the living situation works out with your son. All right, I think all we have left from this morning's calendar are the 3 revocations, Jordan, Massie, and Slay. Is that it for you, Ms. Nix? Thank you. Okay. We can take them in any order.
Just got an email from Miss Ward. What did she say? Oh, he was accepted. Like the Simpson. Well,
Ms. Simpson will be right back.
okay. He looks like he was accepted to drug court because she's in an attorney agreement. So.
Yeah.
So we can. I don't know, whoever. Maybe we'll do.
Well, you're standing up, so we can do, we'll just go in order. Jordan,
Okay.
I guess all 3 of them are yours.
Yep.
Oh.
Be up for a while. Show you the back and front.
Who? I think he's on my screen. Oh, that's right. There's Jordan.
Yeah. Were you on the email she sent? I know, she just sent an attorney for that. I'm sorry.
Back again.
Yeah, well, you're accepted to drug court, so that's good.
Back, but how long does it take you to come and pick you up?
I don't know how long it's gonna take. Hopefully not long.
Oh, Lord.
Yeah, he's accepted. Yeah. Huh?
Okay, let's get on the record. This is position 11, 24 SC 005-669, State versus Alton Jordan. Hello, Mr. Jordan.
Hey, how you doing today, sir?
I'm all right. How are you?
I'm all right.
You're hanging in there.
Yes, sir.
Mr. Jordan, you are here for a probation revocation. You pled guilty to a theft by receiving case back in the day. You've got 4 years and 3 months remaining on your probation. And while you were on probation, a couple things came up. You were arrested in Clayton County in October of last year for shoplifting, which, if admitted to, is a violation of probation. You also were supposed to complete 16 weekends in jail. And it doesn't sound like you did all those. Ms. Rios is going to tell me about that. And then finally, you were supposed to get into drug court, or at least try to get into drug court. It sounds like there were some funky hiccups there, but the good news is, I believe you've now been accepted into drug court, which will become a condition of your probation in this case. But I want to first find out from Ms. Rios if what we're doing today is having Mr. Jordan stipulate to the arrest and admit to the other things, or what's happening?
Yes, we're stipulating to the arrest. I mean, I just want some explanation though. He was told to either do weekends.
Well, the arrest is the Clayton County thing.
Oh, yes.
So that's a pending case in Clayton County?
Yes, he stipulated to the arrest.
Okay. So Mr. Jordan, if you do get into drug court, at some point you're going to need to go to Clayton to deal with that. Hopefully they'll say you're in drug court. Let's roll that into drug court. But we're not resolving the Clayton case. You're just stipulating the fact that you got arrested for shoplifting, which would be a violation of probation. Let's talk about the weekends. What happened?
He was told to either do weekends or drug court, from his understanding. So he did one weekend. The following week, he was arrested. And so that's why, is that?
No, I can speak, Master.
Yeah, yeah.
Okay, this is what happened. Okay, I went to do the weekend, just like you told me to go and report in that following Friday.
Yep.
So I went there following Friday. I went and did the weekend. So at the time, they wasn't sending us up to, you would do the weekend downstairs, I laying on the floor and stuff like that. So
Doesn't sound fun.
no, that was kind of hard for me.
Yeah, but that's part of the point.
Okay, so you said this what you said. You said either, okay, I can stop doing the weekends as long as I get accepted to drug court. So I went to drug court and she accepted me. And I took a picture and sent it to the chief of probation because I haven't got a probation officer yet. All right. But I ended up getting arrested before I could get a probation officer to come out and see me.
Arrested where?
I got arrested in Clay.
Oh, for the shoplifting situation.
Yes, sir. So this, and the day I supposed to report it back to drug court to take her, because you got to take a physical. Right. So that's how I know you had to go take a physical. I had to go take a physical.
Yeah.
She gave me to the 9th. I got locked up. Unfortunately, I get locked up on the 8th. And I supposed to have reported in on the 9th of that month. And
how long were you in Clayton County?
I was in Clayton County. I've been in Clayton County 5 months.
So you haven't gotten out since you were arrested in October?
No, sir. I've been in jail since October and came over here.
Okay, so you were a lateral. It wasn't that you got arrested on this warrant.
I finally got a chance to make bond to get up out of Clayton County. And I had probation in Fulton, and this was sent me to Fulton.
Sure. No, because I signed the probation warrant. Who posted your bond?
My mother.
Okay, your Clayton bond.
Yes, sir.
All right. I didn't realize. So you came from Clayton, having been there for a long time. That's probably going to take care of your Clayton case. I know it hasn't been resolved, but the fact that you spent a bunch of months. What's the allegation? What did you allegedly take?
I didn't take nothing. I haven't went to court on it yet.
Okay. You don't know what they say that you took? Right. Was it a Walmart or a Home Depot or?
No, it was, they said I took some beers up at the store.
Okay. All right. I'm just curious what that was.
No, it really was a misdemeanor.
Okay. You don't need to talk about it. Just wanted to know if it was a car or beer in his beer. Okay. Well, that's helpful to understand. And you've been here, it looks like now, almost a month.
Yes, sir.
Okay. So your understanding was if I get into drug court, I don't need to do weekends. But in some respects, it doesn't really matter what your understanding was because then you got arrested and you've been stuck in Clayton County.
Yes, sir.
Oh. All right. We've taken care of your weekends that way. Ms. Rios, what are you recommending we do in Mr. Jordan's situation?
Continue him on probation, just add the condition that he complete drug court.
Okay. And Ms. Wart said he is in drug court?
So she just sent us the attorney agreement. So I'm taking that to mean he was accepted.
Okay. Got it. I think I understand that. Ms. Smith, what are your thoughts about Mr. Jordan's case?
The state is okay with revoking him to drug court, and also to keep the defendant on probation. I just got the attorney agreement, so I'll go over that, but I think that we're in agreement with it.
Okay. Ms. Simpson, anything different for Mr. Jordan?
No, Judge, I advise Ms. Gibbs that, if he was accepting the drug court, I would still be in the state.
Right. How do we revoke it so that he is released to drug court? In other words, not released today, but you've been accepted in drug court, so they'll probably come get you next Tuesday. Orientation is every Tuesday.
Okay, please, I hope so, because
it is every Tuesday. And if you've been accepted, because the paperwork's not done yet, the lawyers need to sign something. I have to sign something. But they would get you next Tuesday. So I guess we just need to say in the revocation order, release to drug court personnel. And we'll handle it that way. So I think that makes sense, is that I will give you credit for the time you've been in, which is, wow, it's 5 months plus. Add the special condition that you complete drug court and have you released to drug court personnel next Tuesday for orientation.
Yes, sir. Thank you, sir.
Do you have a place to stay?
Right now, I was staying, well, I lost my place to stay since I've been incarcerated, but
right.
I was staying in a room house, but right now I stay, my mama said I can come to her house, but she stays in the senior living. See, that's the problem. And that's gonna be a problem because I don't know, will they let me, well, she wanted to know, would they be coming, because for the simple fact, she's not trying to get in no trouble to have me there. You know what I'm saying? And then my sister stay in DeKalb County. So she would take me, but then I would have to go get out and transfer my probation to DeKalb County and go through too much. So basically, but my mama said she would let me stay there. So I'm gonna have to work, prioritize and see what I can do from there.
Where is the assisted living place?
It's 420 Boulevard.
Okay. Drug court can provide temporary housing for, usually it's up to 3 months.
Yes, sir.
Then you need to be ready to find your own place.
Yeah, a job and stuff. Yeah,
Right.
When I went, the lady, she's basically told me everything what I supposed to do.
Yeah.
And it's just that I got locked up before the day time for me to go back. And I reported the probation. I did everything that I was supposed to do, but I ended up getting incarcerated. That was
Okay.
it.
Well, that'll throw a wrench in things,
Yeah, that
getting
was the biggest
incarcerated.
Just for clarification, while you're in drug court, your case is stable deaths.
Okay.
So you'll be on probation. It's just probation becomes kind of dormant.
Yeah, it'll be drug court, basically.
Correct. There's an investigator in drug court who will make sure you're doing okay away from.
She explained everything.
Yeah. So you listened, but you're still on probation. You're just not having to report. So do you want me to line up the housing, or you're gonna try staying at your mom's?
I'm gonna try staying at my mom.
Okay, we'll see how that goes. So they should come get you next Tuesday. There are 2 drug court judges. I happen to be one of them. So if you end up working with me, that's just a coincidence. Not because, gosh, I dealt with my revocation here. It just, as people come in, one goes to this judge, one goes to that judge. So we may end up working together, which would be great by me. But you may be with my colleague who handles half of the drug court folks.
Okay.
All right.
Okay. Thank you, sir.
Ms. Rios, anything else with Mr. Jordan?
No, you're right.
Ms. Smith?
Nothing further, thank you.
Okay. Good luck, Mr. Jordan.
All right. Thank you, sir. Thank you.
There's, yeah, I can see that you can pull. The piece of another case of yours. I didn't need other case, I'm so confused. This is Jordan, yes, he has this on.
Why don't we do 3? Because we could do 5. He's got enough time left. So revoke 5 months, credit for time served, but release to drug court personnel.
But Clayton case that y'all are talking about. No, I think we're not talking about PI case, but if the PI case, if you are doing PI, it's not with the, you can handle that too. Later, you don't have to do that today, but I'm gonna email. Can you email me the PI? Okay. Or maybe, did you?
Massie is, oh, that was loud. Massie is next. Reesh. Dang.
Okay, just email me and then I'll email everybody about the PI case and ask if we can do delivery back.
It's about pre-indictment?
Yeah,
Yeah,
well,
yeah.
we do pre-indictment.
Yeah.
Yeah, okay, that's fine.
Are you Mr. Massey?
Yes, yes, sir.
Hey, I'm Judge McBurney. Nice to meet you.
Nice to meet you, sir.
We're going to get on the record in your case. It's 12 SC 111308. You're Mr. Massey. You're here with Ms. Rios, who is representing you for this hearing. Ms. Smith represents the state. And Mr. Massey, you pled guilty in 2013, 13 years ago, in front of Judge Downs, who's since retired. I've inherited her docket. And you pled to a burglary, and it sounds like you got one of the Downs specials, which was 1 million years probation. You got parole. Oh, no, you went to prison for a while because you got paroled in 2017. And then there have been no issues for almost 10 years. But in April of last year, you supposedly committed some offenses that I don't quite understand. Use of blue light, and maybe you had marijuana and you didn't stop when the police wanted to talk to you. And this was in Clayton County. So April of last year, some situation with Clayton County Police. I signed the warrant in August of last year, but there's all this paperwork with your warrant about you being in Texas.
Yes, sir.
Which is another issue with probation because you're not supposed to leave the state without telling probation. But that's what we're here to talk about, and then figure out what to do going forward. You've got 6 years and 9 months left on your 2012 case for burglary. Ms. Rios, first, do you know what exactly the charges are out of Clayton?
I am not sure, and I wasn't able to get that information. I know that I think it was just him fleeing.
Okay.
He basically, he had lights on his car that was similar reflected as police lights.
Okay.
And so, that was the nature of why he got.
Got it. The police thought you've got fake police lights. That's not okay. And then there turned out to be supposedly marijuana in the mix, and maybe the pulling over didn't go real smoothly. Okay. All right. Those are the allegations. Have you been back to court in Clayton County for any of that?
No, sir.
Okay. Did you bond out?
Yes, sir. I bonded out and then
Went to Texas.
I'm a box truck owner operator.
Oh, what? Oh, box truck.
Yes, sir.
Oh, so you were on your route.
Yes, sir. And when I didn't know I had a warrant, so I wasn't running.
No.
I went to a military base where, like I always deliver. I gave them my ID. They ran it, and then he came and told me, he's like, "Look, you got a warrant." So
what happened with your truck and what was in it?
My truck it got towed back. I'm paying for that now.
It's in storage somewhere.
No, it's home now.
Oh, but you had to pay for it being towed from Texas to Georgia.
Sir.
But like if your truck was full of chicken or something, what happened to?
Oh, they actually, because I was on the base.
Yeah.
So they actually took all the it was stuff for a tank, military tanks on the back of it. So they actually got it off.
Like
the
rockets?
The tractor.
Oh, the tractor. Okay, so it's heavy stuff.
Yes. So
okay.
they actually got it off.
Got it.
And then told my wife to
towed your truck back. And then how long did you sit in Texas?
I was there for about maybe 30-something days, and then 5 days on the road in Kentucky, and then a day and a half to get here.
Okay. So when did you get arrested in Texas?
January 7th.
You've been in custody since January 7th?
Yes, sir.
All right. Okay. In Texas. All right. What else, Ms. Rios?
Your Honor, he is 50 years old. He has 3 children, ages 26, 21, and 13. He, with regard to well, we don't really have to talk about the claimant case, but we're asking for revoke 2 months and then reinstate the balance. I don't believe he has had any issues on probation. He's started his new business. He's been doing well, and then the situation occurred and kind of messed him up. So, but before that, he held a job for 4 years, then got his LLC and was doing everything it seemed right until the situation where he got pulled over.
Yeah, I'm curious, and Ms. Rios may say don't answer it, but what's the blue light thing?
It's a strobe light, the lights that, you know, people got the underglow lights that go up under the car. So mine is go up under the hood. And usually it's already set at purple or yellow. And so I don't know if he was trying to say they was blue at the time, but I didn't.
Okay, but you had some aftermarket lights on your car that were fancy and looked good, but may have been a little confusing to the police. Okay, understand.
Like I said, they didn't pull me over, and when they pulled me over, he shattered my window. That's what happened. He shattered my window, and I left. But
he fired a bullet through the window?
No, he didn't fire a bullet. Like I guess they got this little thing that could tap the window, and it shattered my right side.
Oh, I thought you said he shot up your window. I got it. So whatever he did broke the window. Okay, I just was curious more about the lights thing. Clayton and you will sort all that out. Ms. Simpson, do your records show any issues with Mr. Massie and probation other than this? Okay. Ms. Smith, I'm inclined to revoke 3 months and then close this out. There's a case from 2012. Mr. Massie had no issues, was running a business, 50 years old. Seems like that's been a lot of probation. What are your thoughts?
That's fine with the state, Your Honor. We don't have any objection to it.
Okay. Ms. Simpson, anything in your system that makes you leery of doing something like that?
This is actually his first operation since we've been there.
Right, so 10 years almost. Okay. Mr. Massie, I'm gonna revoke 3 months of your probation because of what happened in Clayton. And you still have to deal with that. I don't know what the status of that is, so check with Clayton. You don't wanna be a fugitive there because you missed court. And I'm gonna close out this probation. It's been hanging over your head long enough and you were doing fine until your slick lights on your car got you sideways with Clayton Police. You plug back in with your family and your career, and I wish you the best on that, okay? Sure. I don't think you've got any holds. I don't think Clayton is trying to get you laterally, because I guess you got you bonded out and were minding your own business until you were delivering in Texas and this came up. So just make sure you do check in with the courts in Clayton.
Yes, sir. Thank you.
You bet. Ms. Rios, anything else?
Thank you, Your Honor.
Okay.
Thank you.
Mr. Slade?
No, you're fine. Go ahead.
And then I think we can handle our 2 afternoon early arrivals.
Who's here from National Gallery? Yeah, he's with negative. Okay.
Good morning, Mr. Slade.
Good morning.
We're going to get on the record in your case. It's 23 SC 187-328. You're Mr. Slade. You're represented by Ms. Rios here in court, and Ms. Smith is representing the state. And Mr. Slade, we are together because in September of last year, I signed a warrant that alleges that probation couldn't track you down in September of last year. They went to the address of record, which was a Nathan Drive here in Atlanta, left a letter, didn't work, you didn't report. You hadn't done any of your community service, and you were supposed to, I think, get a substance abuse evaluation, and you didn't do that either. So these are technical violations. This is not the biggest deal in the world, but it's also not consistent with you. Uh-oh.
He has 2 cases with Judge Schwab.
Open cases with Judge Schwab? Oh. They didn't make it into the warrant.
They're in the petition.
The petition. Well, hold on, Mr. Slade. What happened to your eye?
Playing basketball.
Let me find your paperwork. There's Slade. Okay. So there were these small things like we couldn't track you down and you hadn't done your community service, but you picked up 2 new cases. So query, and they are part of the petition. Ms. Simpson, do you want to talk to Mr. Slade about this, or have you already done it? That probation really ought to be handled by Judge Schwab when he and Mr. Slade and Mr. Slade's lawyer and the prosecutor are working out those cases.
I haven't talked to Mr. Slade about that, but maybe take a second and.
Okay, well, let me just give you an overview so you know what you and Ms. Rios are going to talk about. You've got 2 cases in front of a different judge. It looks like it's for, like I said, false imprisonment and having a gun. Those, Judge Schwab has those. You have a lawyer there, and you're going to need to sort those out at some point. What often happens is that a defendant says, look, my revocation, part of my revocation is these new charges. Can't we just resolve everything together in front of that one judge with that one lawyer and one prosecutor? And that's fine. I can just have the revocation transferred over there. But it does not have to happen that way. We could have a hearing based on all these allegations, and I can go ahead and say, all right, based on that, I'm going to revoke X, whatever X would be. And then you're done with your revocation, and then you go on and deal with your business in Judge Schwab's courtroom. I'm going to have Ms. Rios talk to you about it because she's going to have an angle on it. It's a good idea. It's a bad idea. And you should hear that angle before you come back out here and let me know through Ms. Rios whether you want to have everything in front of one judge or you want to deal with revocation and your new cases separately. Thanks, Ms. Rios. And thank you, Ms. Simpson, for flagging that. I won on the warrant. Ms. Wood, while Ms. Rios is doing that, can we do one or both of, I don't know if both final pleas are yours or?
Mr. Stringer is mine.
Okay.
Judge, so we're still negotiating with the state, but he has somewhere to be this afternoon. So my thought is if we could just have the final plea hearing, I'll keep talking. And then if we do reach a resolution, I'll just have him hop on the Zoom.
Okay. Meaning it's possible that you guys don't reach an agreement, so we ought to have the final plea so that if he says, there's no more Zoom today, and he'll just show up for trial.
Or I guess it would make more sense to, I'm not sure, because I'm sending Miss Smith stuff and I know that she's been busy, so she hasn't had a chance to look at it.
Yeah.
And he has somewhere to be this afternoon, I think, which is why he showed up.
Where do you need to be, Mr. Stringer? Okay, well, that's important. I want you to be there. When do you need to be there?
I have fee around this time, this is my sheet lunch.
Oh, you need to be heading there soon.
So, shower, so.
Okay, is she at her own home or is she in a assisted living place? Okay, and you are one of her caregivers? Okay, does he actually do it or do you do it? You both do it. Is it his turn today? Okay, all right, then we need to get him there. So here's the deal, Mr. Stringer. Ms. Wood is close, it sounds like, to sorting your case out for you. Why don't we say, do you have a phone?
Yes, I have a phone, but honestly, I'd rather just,
Your call brings in this afternoon?
Yeah, so let me say what I was gonna say, and then I'm not committing you to anything. But my thought was, go take care of your grandmother, feed her, all that kind of stuff. And then we got another calendar at 1 o'clock. And at 1:30 or something, you could pop on, or Ms. Wu could call you and say, hey, here's the deal I was able to get from the state. And you're like, hey, I like that. You can go for it. What you need to understand is that if you do not resolve your case today, which is fine, I'm not putting pressure on you, but you need to know if you don't resolve your case today, you're going to be back here on April 23rd. That's the trial calendar for you. And after today, if you decide you want to plead, you don't want a jury to hear the whole thing, you can. Today, you can withdraw your plea if the sentence I give you is more than what Ms. Wood asked for. So I'll make it up. She says 5 years probation. And I hear about you in the case like, nah, you got to do 6 months in jail and then probation. You could say, I was willing to do probation. No, thank you. I'd like to go to trial. And you can back out of the plea. Today, you can do that. After today, you can still enter a plea, but you're stuck with whatever sentence I impose. And I don't want you to think that I'm going to disagree with Ms. Wood. Sometimes I think she's right on. Sometimes I think she's not quite right on. And I got to do what I think is right. But today, if you enter a plea, if you don't like it because it's different than what she advocated for, you can say no thanks. And then no questions asked. Great, we'll see you on April 23rd and we'll do the trial. So my thought is go take care of your grandma and then dial in, or at least call Ms. Wood because she may give you an offer you love. I will take that. Let's do this thing. I don't want to come back on the 23rd. I don't want to go to trial. I don't know anything about your case. You may have a really strong case. You may be caught on video doing something and then you don't have a strong case. But Ms. Woods talked to you about that and she's now bugging the prosecutor to say, hey, look at this information, look at that. Let's try to work it out a certain way. Does that make sense what I just described? So go take care of grandma and around 1, check in with Ms. Wood, text her or something, say, hey, what's going on? And she may have been sending you information of like, this is what the deal is. And if it's something you want to do, then you can just hop on your phone with Zoom and we'll knock it out that way. If it's not what you want to do, I'll still get you on Zoom. It's just a shorter conversation. You'll just on the record say, no, thank you. I'm not interested in that offer. And then we get you back here on the 23rd. Okay? Do you need to bend his ear before he scoots? All right. You bet. Ms. Rios.
Will they just want handle the probation verification?
Okay.
Will they send it back? Will they take them?
They'll take it. He can just come right to the doorway.
Okay.
Hey, Mr. Slade, it sounds like you want to have everything consolidated with one judge. Yes? Okay, we'll get that to Judge Schwall. Do you know when your next court date is there? Let me see if I can tell you that at least before you get out of here. All right, your newer of the two cases, the 26 indictment by receiving stolen property. You got a lawyer. Is Miss Colangelo your colleague? Okay, you got a lawyer on that one that doesn't have a court date. Your other case, which is the aggravated assault, you got Miss Colangelo. You had arraignment there in January. So you've already met Judge Schwall because you. Oh, okay. We had your arraignment on January 30th, it says on that, but who knows? Maybe your lawyer filled out some paperwork. But you've got a lawyer in that case, and that's who's going to be reaching out to you to let you know when you're next up in his courtroom, okay? All right, thanks. So Ms. Wood, Mr. Stringer will pop on.
Yes.
Then what about Mr. Simpson? Was it Simpson or Williams?
Oh, I think.
I think that's Ms. Wood, the older guy.
Okay.
He is one of the.
Mhm.
I don't think he's gonna sign this.
Pardon me?
Yeah.
The gentleman who just left?
No, Mr. Simpson.
The gentleman who is around?
Yes.
Okay, got it. What's that case?
I think we might actually be able to use.
21 SD 17999.
Got it.
Yeah.
And he has 5 years.
Right.
Is it also a registry?
So, I mean.
That initial case of that.
Okay.
Revocation that.
So. 'Cause I
Oh,
don't know about
okay.
that, but if not, like this would be like
Okay.
my backup plan would be just do draft or something. No, it was just, it started the week and. I was just thinking about it and want, but it did. Okay, I'm just trying to make sure. If they did, possession, we can take. Hold on, I think that, I don't know why the calendar says that, but the indictment just had burglary on it. I think, was it? No, that's right. No. But these days.
Hey, Ms. Rios, the only thing left for this morning, if we're gonna do it in the morning, is Mr. Simpson, but he's wandered off.
So Miss, Nick wanted him to go register upstairs, so that's why I moved him.
Got it.
She said she wouldn't do anything, he does that, and she still needs to look at stuff, we can't do it early, she said. "Look, do it."
So we'll just do it at 1.
Yeah.
Okay, then I think we're done for this morning. And we'll see everyone back at 1 o'clock. Ms. Stallworth, will you be able to join us at 1 in case we have any pleas?
Yeah, Sean, I'll be back.
Great, okay. We'll see everyone at 1 o'clock. Thank you. All right, good afternoon, everyone. We have a final plea calendar. All the cases on the final plea calendar will also be on the April trial calendar. We call that calendar on the 23rd of April, and the trial week is the week of April 27th. So if the case isn't resolved today, see you back here for the call of the calendar that Thursday, and we'll take it from there. Our first three positions are Mr. Godfrey.
Yes.
Ms. Wood, that's your client. Two of the cases are Ms. Smith's and one is Ms. Nick's.
Correct.
All right, what are we doing with Mr. Godfrey?
Judge, I'll go ahead and start with my case. The state is still waiting on the DNA typing results. And I received and let Ms. Wood know that I did ask for it to be expedited. And I believe that they gave me a date of May 15th. And so I'd actually asked that we reset the final plea until after that date, so that
Tell me the date again.
May 15th, let me just actually just confirm that, 'cause that's what I have in my notes, but I just want to make sure that's correct. Yes, May 15th.
May 15th is what you asked for or what they said they would do?
That's the deadline they gave themselves.
You pressed them and they said, all right, we are going to do our best and we will have it done by May 15th. It could be done before then, but they have committed to May 15th to have results that tell you what. I'm not as conversant as you. DNA typing is going to tell you it's human DNA, or it is Mr. Godfrey's or not Mr. Godfrey's, or it's male DNA, or what?
Whether it is Mr. Godfrey's DNA. We
Okay.
have a result as to whether it is male DNA. There is male DNA. We do not know at this point whether it is Mr. Godfrey's DNA.
Got it. And you have a sample from Mr. Godfrey, so you'll be able to, what's happening now is a comparison between what was taken through medical work and then a buccal swab or whatever from Mr. Godfrey, and we're seeing if they're the same.
That's correct.
Okay. And that'll be done by May 15th.
Yes, sir.
Okay. Do you know if the alleged victim in your case is the same as the victim in Ms. Smith's case?
She is not. It is, I believe, a sister or a stepsister in the aggravated assault case, and then the other case is the.
And the case you have, is it supposedly a stranger or someone who knew Mr. Godfrey?
It is kind of an acquaintance, friend of a kind of situation.
Not a stranger.
Correct.
Okay. Ms. Wood, your thoughts about Ms. Nix's request?
I spoke with Mr. Godfrey yesterday. He wants those results, so we are fine with a reset.
Okay. The way these cases would resolve are, he's been in jail for a while.
Right.
But he gets it that the way these cases would resolve probably would incorporate all the time that he's been in,
Yes.
including another month.
Yes.
Okay. I'm okay with that. Can we bring Mr. Godfrey to the door just so I can share that with him? Ms. Smith, you okay with that?
Yes, I know.
Okay. So we have a trial calendar that we're calling on May 7th, and I gave you guys mistaken information. It was my mistake. I had said, hey, it's actually like 3 weeks of trial separated, but it's not. It's 1 week. Each of these calendars is a 1 week calendar. So on May 7th, we call another 1 week calendar up. But that, hey, Mr. Godfrey, I'm Judge McBurney. How you doing? You have 3 cases with me, and one of them is a whole lot more serious than the others in terms of the allegations. And they're only all allegations right now. And that one that is the most serious, there's some DNA work going on. And I just learned from the prosecutor that the crime lab won't have those DNA results until at the latest kind of mid-May. And so the prosecutor was asking that we hold off on having your final plea and rushing all this to trial till those results come in. Ms. Wood, who's your lawyer, said that you also wanted to get those DNA results. And so you understood that we might have a little delay. Instead of maybe going to trial with your cases at the end of April, it might be more like we do that in May after we get the results. Or it's not a trial after the results. But you're entitled to get that. That's pretty important information if there's a DNA match or not a DNA match. Hopefully what I'm telling you is not news. You've discussed this with Ms. Wood? Yes? Okay. So you understand then that I'm going to hold off on having this final plea conversation. Today was going to be the last day you could resolve your cases by way of a plea and still withdraw that plea if you didn't like the sentence I gave you. But we're going to delay that because neither side, the state or your side, has all the information that you really ought to have. If it's not a DNA match, the state's case is a whole lot less persuasive than if it is a DNA match. And so everyone ought to have that before Ms. Wood can really press the state for, well, this is a reasonable deal versus that's a reasonable deal. Does that make sense to you? Any questions about anything? So I'll bring you back here. We'll have you brought back here. Once we get that info, we can do that final plea to see if it's going to work out. And if it's not, we'll always get a jury in here and we'll do a trial. I'm assuming, Ms. Nix, your case would be the one we try first of the 3?
I can't say that for sure right now, but I would guess so.
If the results are a match and Mr. Godfrey wants trials in his cases, why would we not try yours first?
I mean,
assuming you're available, I'm not saying like, but I'm just for planning purposes, because if it's going to be Ms. Smith's case, we could go forward with those cases now. That would mean no global resolution. I'm not trying to rush anything, but it would, I just want to know if there's some reason your case would be tried only if the other two cases, if Mr. Godfrey says, I'm fighting everything. One approach would be, if you're not wanting your case to go first, is Ms. Smith goes with the aggravated assault. And then that may, if it doesn't go well for Mr. Godfrey, then he wants to plead to these other things. But I just assumed, given the seriousness of the charge in your case, that that one would go first.
yes, sir. I think that is what would happen. I just don't want to say 100% for sure if we run into some kind of issue with the witness or something like that.
Understood. Okay. Any questions, Mr. Godfrey? Ms. Wood, anything from the defense side?
No, Your Honor.
All right, Ms. Smith, anything as to the other two cases?
No, Your Honor.
All right, so Mr. Godfrey, we're going to move your things to the next calendar so you can still have final plea, and we'll get you another trial date. I'll see you soon. Ms. Smith, I should have asked while he was here, but it's all right. Any evidentiary issues with your two cases? I don't mean motion and eliminate, but we don't have this from the crime lab or that.
No, not.
As far as you know, they're ready to go. Okay. And Ms. Nix, you'll let us know if you get these results on April 25th. We don't have to wait till May 15th to bug you?
Yes, sir.
Okay. All right. Now we're to Mr. Stringer, and I can come back to him if you still need to talk with him.
It should be a plea.
Okay,
Yes.
he's on.
Okay,
Great.
perfect.
Okay. Hey, Mr. Stringer, how's your grandma?
She's doing fine.
Good. All right, we'll come back to you in just a minute. I'm just going to get through the calendar to see what we're doing, and we'll take your plea, okay?
Okay.
We're back. On April 23rd, we're going to have the conversation that we're going to have today, which is either, is it a plea because you guys have worked something out, or are you on the record going to say, I understand what the state's offer is. I'm not interested in that. I want to go to trial. And then that following week, you can be on the short list of cases that will go to trial, and we'll take care of business then. Does that work for you? Okay, so stay in touch with Ms. Wood. I promise she's going to be in touch with you. And it may well be this is one that works out. Okay?
Thank you, Judge.
Perez Mann.
He is here, Judge. This is a negotiated plea today.
Great. We'll do that in a sec. And Ms. Willingham, your case?
Yes.
All right. Patrick Williams.
That should be a plea at 10 o'clock.
All right. And Michael Simpson is back. There he is. Hey, Mr. Simpson. Ms. Rios?
That should also be a plea.
Okay, we will do that. And Stacy Williams, I see Mr. Wallach here. Mr. Wallach, Mr. Williams has been re-indicted. I don't know if you knew that. Welcome to the news. I learned that, I think, yesterday. And so what we need to do is an arraignment. And then that'll reset a little bit of a clock. I'll tell you from looking at the indictment, it dropped one count and it changes the way in which your client.
So I have to text Roger and get it from Roger. Then I had to say the picture.
The second offense. And you'll read it and you can talk to him about it, but it changes what parts were involved. But same date, same, everything else is the same. Is there any additional discovery or just it was a rewriting of that one count and dropping of the other count?
Yes, it was just a rewriting it just to fix the language to match the facts. And then the third count was a misdemeanor. And so it would be past the statute of limitations.
Okay, so that one's gone. So my thought is we bring Mr. Williams out, and you may want to talk to him first, but if it's a waiver, you can fill out the form. If he wants to be formally arraigned, you can read it. And then we should talk about you and access to Mr. Williams and access to discovery, because you have filed two different requests. One is to have Mr. Williams have extended access to a thumb drive out at the jail. And the other is for you or an investigator to have contact with him. And I've reached out to jail management to find out how they want to handle those. We should just talk about it so that then you can know, here's how we're going to do this one versus that one. And he'll leave with an understanding, you'll leave with an understanding, and then we can start lining up some of those dates because you've asked for more time to be trial ready. I want to make sure as we push that date out, you are able to use that time effectively and not reaching out in a month saying, I still can't meet with him because whatever the situation is. But step one is the indictment. Why don't I print out the new, do you have an extra copy of it?
No.
Nope. I'll print out a copy of the indictment so you can share it with him. And then you can chat with him and maybe after we knock out one of these pleas or something, we'll come out and do that.
And just so I'm clear, so I can explain to him, final plea will wind up to go later.
Correct. I can't do it today because there's a new one. He has to be arraigned or waive it. And so you got at least 10 days before we could do anything with it. You've asked for trial to be moved, so we're not running into that issue. And there'll be a new final plea date. Again, not new facts and circumstances. You'll see from the count, it says something happened in a different way and the misdemeanor's gone. So let me print that out. Elliot Roby.
He is mine, Judge. I think this will be a final plea hearing, but I just need to speak to him briefly before we bring him out.
Okay. Please do. And I know you had asked about likelihood on consolidated trial calendar. We're still later in the list because of having had more cases resolved through that channel. But the other case on it was Mr. Williams, and he has asked for and received a continuance. So now my only case on there, your only case on there, is Roby. So if they get to the McBurney tier, then that will not be first week. First week, I've already sent the list out and we didn't make the cut. Even if a few cases go away, there's still one or two cases ahead of us. So I didn't want, I had said something different last time, but that was before I knew that Mr. Williams was going to want more time.
Thank you.
You're welcome. And then Calvin Andrews. Custody. Ms. Rios?
We are, let's see what we're doing, he's talking, it might be.
Okay, I was just looking at the charges and, but I guess you'll have to talk to him. Okay. Ms. Smith, after her big drug conviction, is coming in hard with this one, offering 10 years.
Not quite 10 years, but more than we would like.
Okay, well, it's not always what he wants, it's to what's practical. All right, so to recap, Mr. Godfrey, we're resetting for the GBI results. Mr. Stringer will take that plea in just a moment, so he's not stuck on Zoom. And then we'll do Mr. Mann's plea. Mr. Williams, it sounds like it's going to be a plea, maybe Mr. Simpson. We will, when I say Mr. Williams, Patrick Williams, Stacy Williams, Mr. Wallach, once you've talked with him and you're back out, I'll slot you guys in between one of those pleas because that's a short conversation. It's happening right now. Yes, yep, I'll get you that before we start the first plea. You'll talk with Mr. Roby, probably not a plea, but we'll get him out here for the final plea part. And then we'll see what Mr. Andrews wants to do with his charges. Great. Here comes the indictment. I won't staple it. How about that? So you don't have to worry about metal going back there. Oh, I meant to during the lunch break to have the IT people come. Oh, you did. But so he knew to come here because you told him? Who told him it was busted? Thanks, team. Excellent. So let's start with Mr. Stringer's plea, please.
Yes, and Judge, just to like give you an idea, I haven't done this in a long time, so he's on first offender probation. I know, but I've talked to Ms. Smith and Ms. Simpson. I think because of the timing, this should not trigger a revocation. And because drugs were involved in this one, I'm asking for conditional discharge. So.
Mr. Stringer is using all his options. Okay, we'll see. All right, let's get our screens going. There's Mr. Stringer. Hey, where'd the big necklace go?
No, I'm in chill mode, man. I'm with grandma.
You're in chill mode. Okay. Oh, I think I see grandma in the background. Hi, grandma. Let's get Ms. Smith. Oh, and we need Ms. Rivers. Ms. Nelson called IT. While we're waiting for Ms. Rivers to come out here, is this plea to the indictment as it is, or charges being reduced or dismissed?
To the indictment.
Okay.
On the calendar, it has 2 counts, but it was only the burglary and first degree that was indicted.
Okay, great. It was an odd combo. That's okay. I snuck out here. Did you get my email about that hearing from long ago? Oh, I sent it. You'll
Was
get.
it today?
Yeah, I sent an email today.
I didn't look yet.
Okay. Let me know when you're ready.
I see.
You're good? Okay. We're going to get on the record with Mr. Stringer. It's 25 SC 005640, position 4 on our final plea calendar, State versus Stringer. Mr. Stringer is appearing from his grandmother's home. His lawyer, Ms. Wood, is here in court, and Ms. Smith, the prosecutor, is here in court. Mr. Stringer, let me make sure you are able to see your lawyer. There she is. You have a right to be here in open court, but you are choosing to appear from your grandmother's house. Are you waiving your right to be here in court?
Yes, sir.
Okay. You also have the right to have Ms. Wood right next to you. So if you need to consult with her, you could just lean over and ask her a question. But you've chosen to be where you are, which is an important place to be. Ms. Wood is here in court. Are you okay moving forward with your lawyer here and not by your side?
Yes.
If you need to speak with her privately at any time, let me know. She can step outside and give you a call so that you guys can speak in confidence. Will you do that?
Yes.
Lastly, if at any point you cannot hear what's going on because you have a virtual connection or you're confused by what's going on, will you let me know?
Yes.
Okay. Ms. Smith is going to put you under oath and then ask you a bunch of questions. Please answer her questions truthfully and completely. Ms. Smith?
Thank you, Judge. Mr. Stringer, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but it?
Yes, ma'am.
You can lower your hand. Please state your true, correct, and legal name for the court.
Travius Rashad Stringer.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 22 years old and I'm in GED school right now.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to the charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Right.
Have you had enough time to speak with your attorney in this case about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am. Everything is understood.
Okay. And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Do you also waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
So waived.
Mr. Stringer, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
We are not.
Mr. Stringer, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 1 month commuted to time served with the balance probated?
Right. Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively? Well, it's only one, but. Do you understand that the court can sentence you to the maximum on this charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, even on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am. I'm sorry, can you repeat that?
Mm-hmm. Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Judge,
So let me clear up one thing in case this is what's weighing on you, Mr. Stringer. You are on probation right now. I sentenced you to 7 years probation on September 22, which was about a week after another judge sent the case you're dealing with right now to us, because we hadn't quite resolved your other case. You're on probation now, but you didn't plead to that case until September of 2025. The conduct we're dealing with today is from way back, it was Christmas Eve 2023. It is earlier in time. And so your plea in this case is not a legal basis to revoke your probation in your other case. Now, if you get arrested later on for something, and just as an example, it turns out, I think you've got a warrant for some driving offenses for something you did on the 17th of February this year. That could be a reason to revoke your probation in that other case. Not this one, because you haven't pled yet, but this plea is not a reason to revoke your 7 years probation because the conduct we're talking about is older than that other case. Does that make sense?
Right.
Okay. We'll come back to that warrant you've got in a minute, but I don't want you to think that if you go through this plea, probation is going to come running after you next week to say, wait a minute, you pled guilty to burglary and now you got some probation issues. That's not what will happen.
Mr. Stringer, are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Right.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense.
Right.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this plea?
I am.
Mr. Stringer, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 005640, how do you plead to count 1, burglary in first degree?
I plead to guilty, right? Yes, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am. She fully explained. Yes.
Do you understand that you do not have a right to appeal to your guilty plea conviction, but if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Right. Yes, ma'am.
Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Sorry, can you explain that one more time?
Yes.
Yes,
Do you
ma'am.
understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Stringer. Your Honor, if this case were to proceed to trial, the state would show that on December 31st, 2023, Mrs. Shaquita Smith, first name is spelled Chiquita, and her husband, Mr. Chad Smith, Chad's common spelling Chad. They went to a property that they owned at 163 Bowen Circle, that's in Atlanta, Georgia, also Fulton County. When they got there, they wanted to make sure that everything was okay. But when they got to the location, that opened the door, they smelled marijuana and observed a laptop on the countertop that did not belong to either one of them. At that time, Mr. Smith told his wife that someone may be in the home. So Mr. Smith entered the home and announced his presence, asked was anyone there, and there was a voice coming from the basement area saying that yes, someone is here. At that point, Mr. Smith started to point his gun at the person who came up the basement stairs, who was later identified as Mr. Stringer, the defendant in this case. At this point, Mr. Stringer did flee from the scene through the basement door. The officers were called to the scene. Mrs. Smith, she told the officers that she took a photo of the suspect while he was still in the home. She provided that photo to the police officers. She also indicated that the man who was in the home left a debit card, some clothing items, and some narcotics at the scene. At this point, the officers checked the name that was on the debit card. They looked at the photo that Mrs. Smith gave them, and they were able to identify the person who was in the home as Mr. Stringer, the defendant in this case. At this point, there were warrants taken out for Mr. Smith, and he was picked up later on for this charge. And those are the facts of the case. Regarding the negotiated plea between the prosecutor and the defense, we've agreed to a sentence of 5 years to serve 1 month, commuted to time served. In this case, the defendant did serve 24 days. So we're just commuting those 24 days to the 30 days he would have served for that 1 month sentence, with the balance probated. As far as the special conditions of probation, we're asking for the defendant to stay away from the incident location, for there to be no contact between the defendant and the victims in this case, for the defendant to complete an anti-theft course, for the defendant to also complete a drug and alcohol abuse evaluation with treatment if necessary, and for the restitution in this case to be reserved. In the facts, Mr. Chad Smith told the officers that there were tools that were missing from the shed that was attached to the home that is believed to have been stolen by the defendant in this case. So the state is just going to be asking for restitution to be reserved upon getting those receipts for the stolen items.
Okay.
Other than that, that's all from the state, Your Honor.
So I may have missed this part. I know there was the smell of marijuana, and originally this case had a drug allegation moving along with the burglary. Ms. Wood is hoping to have this be a conditional discharge disposition, but that requires some connection to drugs. And I'm going to let her articulate that when it's her turn. But what did your review of the police report say about whether they found actual drugs or it just smelled like drugs were there?
Yes, Your Honor. In addition to smelling the marijuana, the officers did find and weighed 74 grams of marijuana that was in the home on that countertop that was also located closely to the ID found that was that matched the defendants.
Got it. Okay. Thank you. Ms. Stallworth, good afternoon.
Good afternoon.
Can you share what criminal history you've got on Mr. Stringer, please?
Yes, Your Honor. He has 5 cycles total. There appears to be an active warrant out of East Point for a flight to avoid. The date of that warrant was February the 17th of 2026. And I also saw the first offender probation for aggravated assault and possession of firearm or knife during commission. That's all.
Okay. Thank you so much. Ms. Wood.
Yes, Judge. So, Mr. Stringer, as you heard previously, he was represented by different counsel when he took the aggravated assault plea. And so that's one of the holdups we've had with this case, is that he was concerned about this case being a problem with his case for that. But of course, these warrants now will present a different issue for Mr. Stringer. But I would just ask for the court to consider sentencing him under 1613-2. There was marijuana usage involved. I think 74 grams is, and the smell of marijuana is enough to know that there was marijuana use involved in this crime. So we would ask for conditional discharge. Otherwise, I don't know that he's had any issues with probation. I think he is a good candidate for this sentence. So we would just ask that you accept the state's recommendation.
All right. Ms. Simpson, is there anything in the system about probation troubles for Mr. String? He's doing his GED, which is good. That was one of the requirements. He hadn't been on all that long. It was a plea in September, but we got 6 months under our belt.
Yeah, he has filed an abuse of provide, without his conditions still so far.
Okay, got it. Mr. Stringer, do you have any questions about the things we've been discussing?
No, sir. No, sir. I'm listening. I
Well, I know you're listening.
I didn't know anything about no warrant though.
Okay, I'll get to that. I'll talk to you about that in a minute because you're going to want to address that. This situation that we're here for, Christmas Eve 2023, this house on Bowen Circle, was that where you were staying at the time, or was that just sort of like a hangout?
No, someone actually sold me the home and gave me a lease. I signed a lease. That's why I told them when they came in the house, like, yes, someone is here.
Oh, you're saying that someone represented that, hey, I've got this place you could rent. And
yeah, you get what I'm saying? I was 19 years old. You get what I'm saying? So I'm just trying to get my own home. You get what I'm saying? I don't.
How much did you pay?
I gave them $7,000 cash and met them in front of the home. Like,
wow. How did you have $7,000 as a 19-year-old?
I was just working. I always had a job. I'm like what I'm doing now. I drive box trucks.
Okay. Next time, don't give anyone $7,000 cash. That's my free advice to you.
I learned that when that's what my public defender told me. Like, and I sent her even the lease and all that. Like, you get what I'm saying? Like,
okay, I'm hearing you, and that's probably why this didn't go to trial and why you got this offer, even though there's been some other things going on. But some things are too good to be true. And someone saying, "Here's this great house, just give me a bunch of cash, and it's all yours." And it wasn't even theirs to let you be in. I'm glad no one got shot. It sounds like that guy drew down on you because he didn't know who was in the house.
Scared me. This is why I'm showing them my phone. Like, look, this the lease. Like, someone sold me this home. Like,
yeah.
So that's what just had me like leave, because I was in fear of my life of being shot. Like, I didn't. You know what I'm saying?
I know what you're saying. And so I want to see if I am correct. You staying at Lyle Place now?
No, sir. That's the old address. That's the old address.
I've shared his most recent address with Ms. Simpson.
Okay. And I don't really need to know the specifics of it other than where are you staying? Are you staying with family? Do you have your own spot? Did you give someone $5,000 to live there, or what's the deal?
No, I'm staying with family right now.
Okay. And is that a stable place for you? Because probation needs to be able to find you. You can't be bouncing from couch to couch.
Oh, no. I already called in, did my monthly check-in and changed the address. And also talked to my probation officer about the address too. She knows, like, it's a family member, my cousin. She's also on my emergency contacts too.
Okay.
So, yeah.
What is your probation officer's name?
Officer Yancey.
Okay. All right. That's good. You know her name. And she has your phone number?
Yes.
Okay. Well, good. He reported today. All right. They must not have run his warrants. All right. Mr. Stringer, let's take care of this case first. I find there's a factual basis for your plea. You had a good defense. You had a lease, but it turns out not to have been your place. I think this is a very reasonable resolution. So I'll accept your plea. I find that your plea is knowing and voluntary, meaning you've understood what we talked about. And if you didn't, you asked. And it's voluntary in the sense that no one is forcing you, twisting your arm to take the plea, but you've decided it's in your best interest to do so. Is that correct?
Right.
Okay. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith, can we sign for you?
Yes, Judge.
Mr. Stringer, is it okay if we electronically sign your name to the indictment indicating your guilty plea?
Yes.
Okay.
Can I also ask the public defender a question too?
Sure. Why don't you ask the question like this, and then if she needs to answer in private, she can give you a call.
Okay.
Or do you not want me to hear the question?
Is it about this case, Mr. Stringer?
Yes.
Okay.
It was mostly, I was just asking just to make it make sense to myself. Like, okay, like what I just explained to you guys, right? Do that make the most sense? Like with me pleading guilty, like basically saying I did burglary when honestly I didn't. Like,
So it's a great question, and it makes sense to work your case out if you think working your case out is the right idea. And it would be an interesting legal question about whether you committed burglary or not. Mr. Smith would say you did, that you were in his house without permission. And I think factually that's correct. But you were in the house with the permission of the person you thought could give permission. And so you'd have a great defense, and a jury would have to wrestle with that. Like, well, was this just a mistake on Mr. Stringer's side, or what? So what you are doing by entering this plea, and I should be clear, I'm going to accept it as a conditional discharge plea. So it's technically not a guilty plea, and it's not going to be a conviction on your record, just like this first offender, because it's kind of connected to you having the weed that you had in there, et cetera. But I think I understand your confusion, but I can also understand why you wouldn't necessarily want to go to trial. Based on what was found in the house, the jury might think, wait a minute, you did what? You paid some money to be in there, and were you operating this as a marketplace or who knows what? So I think there's some complications for you in the case as well. And so I can understand why you'd want to try to get this conditional discharge. But I may not have answered your question, and you may have wanted to hear from your lawyer. Do you want me to have her give you a call, or are you okay going forward?
I'm okay with going forward.
Okay. So I am going to accept this as a conditional discharge plea, which is a whole lot like first offender, which means if you manage not to screw up while you are on probation, then this can slide off your record a few years down the road. But there's stuff riding on it, just like the other case. If 6 months from now you get arrested for something new, that's going to be something that is a problem for you. These things that were in your past are in your past. You don't need to worry about them so much. This new warrant will have no effect on this case. The new warrant may be a little complicated for the case you pled to in September, but we're not working that out today. You don't even know what those charges are all about. I'm going to sentence you, Mr. Stringer, to 5 years to serve 1 month with the balance on probation. You're not going back into custody. Special condition of probation number 1 is that you complete your GED. That's already a requirement in your other case. Special condition number 2 is that you stay away from 163 Bowen Circle. Is that, I don't know how far that is from either your grandmother's house or your cousin's house. Is it far away?
Yeah, it's in the area. You know, Atlanta is small, so it's in the area, but that's a neighborhood. Like my grandmother stays all the way on the other side of,
Okay, Atlanta's small, but I would not want to walk from East Point to
I don't
Alpharetta.
even walk.
Yeah, so don't go near Bowen Circle, okay?
Understood.
All right. Also, no contact with that guy who pointed a gun in your face, Chad Smith. Don't go near him.
No.
Good. Shaking his head. And finally, you are going to, and probation will help you arrange this, you're going to meet with some medical professional and have a drug and alcohol abuse evaluation. And if that person concludes, based on you being real honest with them, like, hey, you know what, I drink a little bit of this or I smoke a little bit of that, you may have some drug treatment woven into your probation. But if that person says there are no issues here, then you don't have any treatment. I am adding that only to help you if you need help in that space. And you may not need help in that space, in which case it's an easy evaluation and nothing flows from that. Ms. Smith, anything else in Mr. Stringer's case?
Nothing further, thank you.
Ms. Wood?
Only Judge, I might have missed it, so he actually served 24 days. I just want to make sure that the paperwork, that the jail doesn't say, oh, he owes us 6 days.
So it's a good question. I've never had the jail come running after someone saying, where are those 6 days? If he were still in custody, then we need to talk about it because it would probably mean he'd do 6 more days. I think we're okay. If not, someone just needs to let me know.
Perfect, thank you.
Here's where you're not okay, Mr. Stringer, and you are going to want to talk to your probation officer or talk to Ms. Wood, not right now, offline, But you do have these five, I'm gonna say 5 warrants, don't panic, it's all one incident. But there are 5 warrants listed because it's different allegations relating to the one incident. And let me pull it up. I'll give you a little bit of information. So something supposedly happened on February 13th in East Point. Seatbelt violation, not obeying either a red light or a stop sign, changed lanes, reckless driving, and then the police say they tried to pull you over and you didn't stop right away. I don't know anything more about it than that, but there are 5 warrants, all related to this one thing with your name on them. And you want to get out ahead of that, because if you get stopped for some other reason, they're going to run your name and these are all hit. And that leads to a much more complicated encounter with the officer. So probation, you could talk to Officer Yancey and say, hey, what's the best way to deal with this? And she might say, you got to go to East Point or wherever these warrants are from. Ms. Wood might be able to get a sense of what to do with it. I can't give you advice in other than you need to take care of these things because they're going to be rattling around out there and you do not want them to catch up on you. You want to go deal with them. Does that make sense?
Understood.
Let me see if I can get it won't let me open the document. I was going to try to get you some kind of information beyond that, but I can't. It's just those warrants all from that date. And I think Ms. Stallworth said it was out of East Point. So follow up on that, okay?
Understood, sir.
What about reporting instructions?
April 10th, at 9.
Okay. Mr. Stringer, you should write this down. And Ms. Wood may shoot you a text about it as well. But you need to go, you know where the probation office is?
Yes.
Where is it?
It's right there, next to, it's right next to the train station. The train station right there by Underground.
Okay. I'll say it's kind of like that.
Like 14th Street, like.
It's on Memorial Drive.
Yeah, Memorial Drive, yeah.
I'm going to send you the address, but you need to report there on April 10th at 9 a.m. 9:30? 9:30 on April 10th at 9:30. I know you already have Officer Yancey, but you have to, I'm going to call it register for this new case as well. And you'll end up with just one officer and it'll probably still be Officer Yancey. You don't have to report twice because you have 2 cases, but you have to do intake for every case that you've got. This is a new one. So you got to go to that office on Memorial Drive and do your intake and go from there. Okay.
You said
All
April 10th, you said April 12th?
Nope, April 10, 10.
April 10, sorry.
Yep. Next Friday, 9:30 at their offices.
Okay.
All right?
Yes.
All right. Give my best to your grandmother.
Tell him, hey, Grandma.
Thanks, Grandma.
All right. Grandma, keep him out of trouble.
Okay.
Yeah. All right. If she had a cane, she could whack you on the head with that. Tell you to do right. Okay, Mr. Stringer, good luck with everything.
All right. Thank you.
All right. Bye-bye.
Bye-bye.
Okay, Mr. Wallach, if you had a chance to go back there, can we bring Mr. Williams out? You see it? Great. Yep. So hopefully that goes way back in time, but I don't think it would be a long transcript, but they need it for, he's competent again. And they want to move forward and that's become an issue. So the Stacy Williams, we want Stacy Williams.
Does you want us up at the podium on the table?
I'm fine, podium or even by the door if it's not a long talk, but podium is fine. Why don't we do podium just because we're gonna have a little bit back and forth about how to check out the evidence.
The first case we did that.
You got it. Excellent. Okay. Thank you. Hey, Mr. Williams, come on up to the podium and stand in front of the screen, please. All right, Mr. Wallach, we got to cover 2 things this afternoon with Mr. Williams. One is whether you're going to waive arraignment
We are, Judge, and I went ahead and filled out the form that you pointed to and.
Excellent. If you'll give that to Deputy Gordon, he'll get it to me and we'll get it filed. Thanks for coming by, college students.
Oh, thank you. We'll be right back.
Okay. All right. So we took care of arraignment. Mr. Williams, the state superseded the indictment. Mr. Wallach told you what's changed. One count went away, et cetera. The other thing we need to work through is enabling Mr. Wallach and Mr. Williams to spend more time together, and you, Mr. Williams, to be able to review digital evidence. The sheriff's team has told me they would prefer transporting you here, and when we're down some morning or afternoon, have you sit right there with a laptop and watch the video rather than having the law library exclusive to you and you handling digital media. Their preference from security and staffing was to do it the way in the past I thought they didn't want, which was to use transport, but they were very specific. And you're welcome to be here, or an investigator can be here.
So, and obviously not disputing what they told you, what they told us was we could do it on a flash drive and he'd have access in the law library.
Right.
So, which is why we requested it that way.
And it was a great request. And so I went to the tippy top and said, I've not really had a request like this. I want to do it the right way. And the answer I got was, we will not fuss it. They used to fuss it. You brought someone over so they could watch it. Let's do that at the jail. Staffing levels are different now, I guess. And so.
So with that in mind, because that goes to one of the other requests, do they prefer that if I need to meet with Mr. Williams, or my team, my investigators do, and we need to meet with him in what we call a contact visit, which means not through the glass where we can't hear each other and
Right.
couldn't really play a video and talk about it and go back and forth. They want us doing that here.
I asked that question as well.
They want that there.
Yes, but that would be, if that's the only thing you're doing, it would be there, because you have the additional request of Mr. Williams reviewing digital evidence solo, because often the lawyer says, I want to watch it with, or my investigator is going to watch it with. That's a contact visit there. But if he's going to watch it solo, the answer I received is then we'll bring the inmate here and he or she can watch it in a private courtroom. No one else is in here, et cetera. You may want to combine the two. And if you do, you are welcome to do it here if that's your preference. And that would just mean coordinating schedules, because it would need to be a morning or an afternoon when I don't have court out here. And so that's why I wanted the three of us to be talking about it. You can do both. I just haven't signed the contact visit order yet because I wanted us to have this conversation. If you want to have the order in place where you can flash it and that gets you and a laptop into a conference room with Mr. Williams at the jail, I'm happy to sign that. I don't need to sign an order to have Mr. Williams come here. I just order him up, but I would need that flash drive and some device on which to watch it, which would mean you or an investigator would be here anyway. So query, do you also then want to do the jail one? I'm open to whatever. I'm just going to follow the request of the sheriff because they do great work for us and they are thinly staffed.
Right. No, I appreciate that. And I appreciate you clarifying the way that they want it, because that's at the end of the day how it has to get done.
Amen.
So if I want to have Mr. Williams here, whether it's meeting with me or the investigator or on his own or whatnot, coordinate it through your office?
Yep. You'd reach out to Ms. Nelson and she'd look and say, hey, Tuesday afternoon, we don't have court. And so we'd make sure that Mr. Williams is brought over. He'd be brought over on a morning bus. But then once we're done with court, Deputy Gordon will get him, bring him up, and then he just locks the courtroom. He can be in his office and there's no one in here, other than if you were going to be here or an investigator, but it would be, we'll call it defense team only.
Okay.
And that can serve both purposes. Mr. Williams reviewing it by himself, or you or an associate being here with him.
And in terms of contact visits at the jail, I assume based on your conversation with them, you have what you need in terms of language for a proposed order for that.
Yes, I just needed to know if you also wanted that. And that's why we're talking, because you might have said, oh, come here. I'll just soon be here and not out there.
I think I would, and I think that would give me the ability to see whether that actually works. And if it does, we may not need to bother you, or maybe that's not as effective and we do need to bother you a little bit.
Got it. So I will do the contact visit order. And that's not for a specific date. It is an authorization. And then you coordinate with the folks at the jail. They give you the windows that work or don't work. You've done that before. I don't know how that flows, but I'll do that order. Then I'll wait to hear back from you if you then want to supplement that with having Mr. Williams come over here to look at stuff because he said, look, I need some time alone with this, or you only have an hour, but it's a 3-hour video and he wants to see the rest. That might be something we do over here, but I will stay out of it unless I hear from you.
All right, terrific. Well, thank you.
You bet. Mr. Williams, the other thing that your lawyer and the prosecutor and I discussed is scheduling. Today was supposed to be a final plea date, which was the last day you could enter a plea if you were interested in entering a plea and have the ability to withdraw that plea if that's where you were going with the case. That's not happening for 2 reasons. One, this new indictment resets a clock, just 10 days worth, but I wouldn't make you think through this new indictment so quickly. But also Mr. Wallach has asked that I take your case off of, it was on 2 not quite overlapping trial calendars. One starts on Monday with a senior judge who comes in and helps us with cases. And then the one I have starts in a couple weeks. And Mr. Wallach indicated that he will be more effective and more prepared to do the work he needs to on your behalf if there was a little more time in there. And so I didn't remove them. They're still printed on the calendar, but they're continued. So you will not come back here for the call of this upcoming trial calendar per Mr. Wallach's request and an order that I entered granting that continuance. Yes, sir. I'm sure you guys talked about it, but I wanted you to hear it from me so that you're like, wait, why am I not coming back to court? I told you why, because your lawyer asked for it. Okay. Ms. Nix, anything we need to hear about from the state in connection with Mr. Williams's case?
No, sir.
Okay. Have you, today was going to be final plea. Had you communicated an offer to Mr. Wallach, or because you knew you were going to supersede, you guys didn't get there?
I did send an offer.
Okay, excellent. I'm glad that those conversations are happening. I'll take care of the contact visit order and we'll go from there.
Terrific. Thanks, Judge.
You bet. So can we do Mr. Mann? This is Mr. Mann?
Yes.
Can we do Mr. Mann now?
Yes.
Okay, great. Mr. Mann, if you'll come on up and stand in front of that monitor there, please.
Right.
I'm sorry, there are 2 monitors. Stand by your lawyer. Let me know when you're ready. Ready, Ms. Rivers? Okay, we're gonna go on the record. This is State versus Mann, 25 SC 005-722. Mr. Mann is here in court with his lawyer, Ms. Wood, and Ms. Willingham is representing the state. Mr. Mann, Ms. Wood tells me, and you heard her say it, that you are ready to enter a plea in your case. Is that correct?
Yes, sir.
Okay. I'm assuming something is changing with how it's indicted?
Yes, Judge.
Okay.
And if you want me to go ahead and put that on the record now.
No, I just was, I'll let you get that on record in just a moment. Mr. Mann, in a moment, Ms. Willingham's going to put you under oath, and then she's going to ask you a bunch of questions. You heard most of them in a plea you just listened to. They're going to be similar, but they're going to be tailored to you and your charges. You need to answer those questions. Okay. But you also need to let Ms. Wood or me know if you've got questions of your own. If something's confusing or you didn't understand what someone said, will you tell me?
Yes, sir.
Okay. Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name.
Perez Island Man.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
43, GD.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Have you reviewed the indictment in this case?
Yes,
Do you waive formal reading of the indictment?
I do.
Has your client been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges?
We do not.
Mr. Mann, do you understand you are entering a guilty plea to the following offenses? As to count 1, kidnapping, the state will be reducing that charge to aggravated assault under 16-5-21, which has a minimum of 1 year and a maximum of 20. As to count 2, criminal damage, As to count 1, the sentence recommendation would be 5 years probation. As to count 2, the sentence recommendation would be 5 years probation to run concurrent with count 1. And as to count 3, the sentence recommendation would be 12 months probation to run concurrent to count 1. And the parties have agreed that counts 1 and 3 will not merge in this instance for the purposes of the negotiation. And there would be no contact with the victim, complete family violence intervention program, complete 60 hours of community service, have no weapons, and seek and maintain gainful employment. Was this explained to you by your attorney?
Yes, ma'am.
And do you understand that this is a negotiated plea of guilty? However, the court can sentence you up to the maximum sentence of each of these charges, and they can run those sentences consecutively or one after the other?
Yes.
And do you understand that if you do not accept the court sentence, you may withdraw your guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand, are you on probation or parole for anything, anywhere?
No.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you could be found guilty of another felony?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Just say yes. Yes.
Yes.
How do you plead to the reduced charge of aggravated assault, the charge of criminal damage to property in the second degree, and battery in indictment 25 SC 005722?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today. Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, if this case were to proceed to trial, the state would expect to show that on October 5th, 2023, officers with South Fulton PD responded to a domestic dispute at 4422 Estate in South Fulton County. Upon arrival, officers spoke to Miss Jamaica Johnson, who advised that her boyfriend, Mr. Perez Man, got angry over a social media post and hit her in the face so hard that she lost consciousness for a moment. When Miss Johnson tried to get away and go inside her home, he grabbed her by her hair and dragged her against her will into his car and drove her to a home in DeKalb County. Miss Johnson had to contact a friend, Miss King, to come pick her up and call 911. When Miss Johnson was able to get back to her home, she noticed Mr. Mann damaged her 70-inch TV and put a hole in the wall. Warrants were obtained and the defendant was later arrested. Your Honor, I have had an opportunity to speak with Miss Johnson, and for the record, she is not happy with the state's recommendation in this case. However,
In which direction? She thinks he should go to prison, or she thinks you should drop the case?
she thinks that he should go to prison. However, in further review of this case, it is also our understanding that Ms. Johnson stated that she also contacted law enforcement in DeKalb County. She said that DeKalb County did arrive to the home. However, they told her to go back to Fulton County and contact law enforcement there. Based on some of our investigation, although we do not negate that that call was made, we share some of DeKalb's concerns as to why they did not make an arrest at that time. As Your Honor recognizes, that a kidnapping charge would be a continuing crime. So there would not have been a reason for them to not arrest the defendant at that time. It is our understanding from speaking with the victim that she arrived to the home with the defendant at the same time as her friend and law enforcement. So that also drew a bit of concern for the state. However, we do not have any reason to have hesitation as to what happened outside of Miss Johnson's
Sure, the
home.
assault and busting up the TV.
Yes, as officers were able to see that her TV was damaged, that Miss Johnson did have injuries to her leg, where she had some scrapes on her leg that were they weren't small scrapes. And she also had some braids missing out of her hair. So we have no doubt about the aggravated assault, the criminal damage, or the battery. We just do believe that the kidnapping may not have been as strong of a case. Not to say that Ms. Johnson did not feel that she was unable to leave or that she was taken against her will, just that we recognize some of the hurdles we would have in presenting that charge to a jury.
Has she shared any concerns about Mr. Mann not staying away from her? This is now 2.5 years, and that's a great test to see if Mr. Mann is going to comply with Ms. Johnson needs to be able to lead her own life.
So they were actually still together up until based on our notes, it looks like about a year ago is when we can say there was for sure no more contact.
Okay.
But since that time, she has not said, when I spoke with her the other day, she has not alleged that the defendant has made any communication with her. She obviously wants that no contact to remain in place. But
The contact that happened, say in 2024, would have been contact that she consented to.
yes, Your Honor.
Okay. All right. Thank you. That's helpful. Ms. Stallworth, do you have any criminal history information for Mr. Mann?
I do. He has 23 cycles total, 11 from the state of Florida, 1 from federal. There is an 01 conviction for trafficking in cocaine. And then there was a 2021 FTA out of Avondale. Nothing further.
So 1 conviction, and it's from way back in 01.
That's what I saw, yes, Your Honor.
Okay. What was the federal cycle?
I think it might have been the trafficking. Let me check.
You want me to tell you,
Sure.
It was a profession. I caught a track when I was like 17, and I turned kind of like an adult in prison. Then right after that, like 3-4 years later, I got caught with a firearm. So they sent me to the feds for being a felon with a firearm.
Okay. Just 1 felon with a firearm, but it went federal.
Yeah.
Was it here in the Northern District or in Florida?
I caught it. I was living in Florida. I caught it in Alabama.
Okay.
And Alabama sent me straight to prison after that.
Well, there you go.
The cycle here is showing for a probation violation through the U.S. feds before the transport of firearms.
Okay. Thank you.
You're welcome.
Ms. Wood.
Yes, Judge. So he did 26 days in Fulton County Jail for this case. He's 43 years old, as you heard. He does have his GED. Your Honor, he's starting a new job this week. Tomorrow. He's a chef by trade.
I lost my jobs because of the kidnapping thing, so it's been hard.
And so we appreciate Ms. Willingham working with us on the charge change so that he can hopefully maintain this new job that he's getting, Judge. I did want to let the court know, so he does have 2 children. One of the kids is with the victim. However, he is aware he's fine with the no contact. I think that he has actually had no contact.
Yeah.
He's never met the baby.
Even with the kid, after I went through this, like, I don't even know what to say. I don't know what to do. I just don't want to be around it.
I've advised him that if he should change, that needs to go through family court.
Yep.
And so he understands that, Judge. And lastly, he is asking the court to consider setting a behavioral incentive date for this case.
Okay. Where are you going to be a chef, Mr. Mann?
I started at Mission Burger tomorrow.
Where's that?
It's like Howell Mill. I was a chef at the
long. What's it near? It's just on Howell Mill.
Yeah, I'm sorry.
That's okay.
Yeah.
Mission Burger. How'd you get the job?
Through a reference. That's actually my old boss came with me at my other job.
Okay. What was your other job?
I was just chef at the Battery.
Okay.
Yeah, I was a great chef there.
I bet you're a great chef wherever you are.
Yeah.
Why did you shift from the Battery to Mission Burger?
Had got a promotion to another restaurant called Walk On. They promoted me and offered us a lot of money, and then it didn't end up working out at the restaurant.
Okay. So Mission Burger it is starting tomorrow.
Yeah.
Okay. And is that actual like beef, or is Mission Burger it's made out of chickpeas?
It's all vegetarian restaurant.
You all right with that?
I'm finna lose some pounds. I'm finna learn.
All right. Good. Mission Burger it is. So you have 2 kids, one with a different woman than Ms. Johnson.
Yeah, my son, he normally he was coming to live with me and Ms. Johnson back and forth from Florida.
Okay.
So I kind of ain't let him. The first move I got, I ain't know how to talk to him because everybody familiar with the case, the family. So it was just.
How old is your son?
He just turned 18.
18. He's a big kid.
Yeah.
Okay. He goes where he wants now.
Yeah, he like me though.
Okay. And is he in high school? What's his deal?
He just graduated.
Congrats. What's he gonna do?
He doing music and he want to take a trade and I'm with him whatever he want to do.
Is he based in Florida? Home is Florida?
Yeah, kind of back and forth.
Okay.
He come live with me and live in Florida.
Okay. And what county do you live in?
Douglasville.
Douglas County?
Douglas County, I'm sorry.
Okay, that's okay. All right. You got, looks like it got dismissed, but you had an arrest or something in May of 24. Failure to obey traffic sign, possession of cocaine, couple other things. Did that go away?
Yeah, the cop pulled me over and he found a baggie and charged me. It was some more people in the car, and then ended up going to court. They threw it out.
They threw it out. Okay.
Yeah.
Got it. Okay. Do you have questions about any of the things we discussed?
No, sir.
Okay, well, I'm going to accept your plea, Mr. Mann. I find there's a factual basis that you and Ms. Johnson got into it in October of 2023.
Yes.
You did some things that a big guy needs to not do to someone, which is why you'll do the Family Violence Intervention Program.
Right.
I also find that your plea is knowing and voluntary, meaning you've understood what we've been talking about,
yes,
and
sir.
that no one's forcing you to enter the plea. You agree with that?
Yes, sir.
All right. Ms. Wood, can someone in my office sign the indictment?
Yes, Judge.
Ms. Willingham?
Yes, Judge.
And can we sign it for you, Mr. Mann?
Yes, sir.
Great, we'll do that. So here's how I'm going to sentence you. On count one, I am sentencing you to 5 years to serve 1 month. You actually did, if you add up the two different stints in 35 days, so a little more than a month. So 5 years to serve 1 month with the balance on probation. Count two is going to be 5 years to serve 1 month, balance on probation. And then count three is 1 month to serve. They all run together. So total sentence, 5 years to serve 1 month. So you've got 4 years and 11 months probation.
Yes, sir.
Special condition number one is leave Ms. Johnson alone. No contact. Don't call her. Don't write her. If in your heart you find, I want to spend time with my little baby, like Ms. Wood said, then you're going to need to go through the courts. If you're the biological father, you have certain rights to be with that child.
Yeah.
But you can't just call Ms. Johnson up and say, hey, I need to see the kid.
Right.
Because that's you contacting Ms. Johnson.
Right.
And it sure sounds like she's going to call Ms. Willingham right away and say, guess who just called me?
Yeah.
And then we're going to be back here and you're going to lose your job at Mission Burger. You're going to say, that's fine. I didn't like chickpea burgers, but you'll go to jail and that will be bad.
Right.
So no contact with Ms. Johnson.
Yes, sir.
You'll complete a family violence intervention program. That's not one class, it's a series of classes, but they're good classes and you'll learn from them. You need to enroll in the family violence intervention program within the first 3 months of probation.
Okay.
So not tomorrow, not next week, get settled with your job, but within the first 3 months, you got to start those classes.
Yes, sir.
You also need to, within the first year of your probation, complete 60 hours of community service. And since your only other conviction is from 01, I will set a behavioral incentive date. It will be April 1 of 2029. So that's 3 years from now.
Okay.
If you have done everything you need to do, taken your classes, stayed out of trouble, left Ms. Johnson alone, then a couple of years early, probation can say, hey, Mr. Mann is squared away. Heck, by then he's 45 years old. He's working. Let's let him go his own way.
Yes, sir.
So you control that one. If you're a pain in the rear and you aren't showing up for meetings or this or that, then they'll say, hey, we'll just do the full 5.
Yes, sir.
Ms. Willingham, anything else on behalf of the state?
Nothing from the state, Your Honor.
Ms. Wood?
No, Judge, thank you.
Ms. Simpson, what are the reporting instructions for Mr. Mann? He will be reporting in Douglas County. I don't know where he goes for that.
Okay. Just there.
Yes, witness reporting date will also be
At 9:30 a.m.?
at 8 a.m.
8 a.m. Wow, they start early in Douglas County. Okay. Mr. Mann, Ms. Simpson's going to meet with you in just a minute. She's with probation, but she is putting on the record that your reporting date for probation is April 10th. That's next Friday, not this Friday, the Friday after at 8 a.m. At some place in Douglas County. She's going to tell you where. You don't have to guess.
Okay.
But that's your kickoff appointment. And they're going to be waiting. If you don't show up, it's 9 o'clock. They just send me a warrant to sign. We say, Mr. Mann didn't even show up for his first meeting with probation. So don't miss that. That's a hot date.
Yes, sir.
Okay?
Yes, sir.
All right. Good luck.
Okay.
All right, thanks.
And Judge, that concludes my business. May I be excused?
Yes, ma'am. I'll see you around. Thank you.
Yep. The recidivism thing, I actually didn't realize that draw on chart on
Yes.
That was why I was so confused when you were saying that, like, I literally ran out of here. Like,
Oh.
y'all gotta show me how to do
Yeah,
it.
you pick or choose.
Yeah.
Yeah, good.
First, we'll do Mr. Simpson next.
We can do whoever you'd like to do next. Ma'am, in the way back, who are you here for? Oh, well, there we go. Are you here in support or opposition? Or you're not sure? Okay, I'm glad you're here. Okay. Ms. Nix, this is your case. That's okay. And Mr. Abadi was here and then he left. Will one of you be handling whatever we do with Roby, or is he coming back?
I'll shoot him a text.
He doesn't need to come back right away. We've got a couple other pleas before then, but we'll do Mr. Simpson and then we can figure out what we're going to do after that. Let me know when you're situated.
I am ready, Judge.
You're ready. Excellent. Okay. Let's get on the record with position 8, State versus Michael Simpson, 25 SC 005919. Mr. Simpson is here with his lawyer, Ms. Rios. Ms. Nix is here for the state. And Mr. Simpson, it's my understanding that you're prepared to enter a plea today. Is that correct?
Yes.
Okay. I think, and hopefully this is not a surprise to anyone, we also are going to handle a revocation because this plea would constitute a violation of Mr. Simpson's probation in a 21 SC case. And I'll get all that on the record. I don't.
That you have your own, remember, you're on probation, so you have to handle the probation revocation hearing too.
But I have no probation.
So let's work through this. 21 SC 179995. Pulling the case up now.
And just so you.
Michael Anthony Simpson in front of Judge Whitaker. You were represented by Larry Korn, and you pled to aggravated battery and aggravated assault. But let's see what the actual disposition was. It was in August of 2022, so it was a few years ago. But you did plead, you got 10 years to serve 1 year with the balance probation. So 9 years probation, and that's it. That's what happened. You remembering this?
I don't remember Larry Corm. I had a woman for a lawyer.
Okay. Yep, you did. Look at that. Corrine Mull handled the plea for you. I think maybe Mr. Korn may have been assigned at one point. So when it pulled up the case, it said, hey, your lawyer was Mr. Korn. But when I look at the actual plea that you took, there was a Corrine Mull, who is a woman.
Yeah, I never did meet Mr. Corn.
Okay, well, he's a busy
I
guy.
spoke to him either.
Okay, well, but hopefully you spoke with Ms. Mull.
Yeah, she was my lawyer.
There you go. So now you remember the case we're talking about.
Her.
Okay, well, you're on probation in that case. So we got to deal with that today as well.
They dismissed all the charges in that case.
So you did have a revocation in October, and maybe it was related to this, in which case we don't need to do things twice. It was not? Okay, you had a revocation in that other case in front of Judge Brooks because you didn't report. So you had not been reporting the probation, and you were in front of a judge just a few months ago who said, hey, you need to start reporting the probation. You remembering that?
I completed probation in 2018.
Must have been a different case because this case happened after 2018.
I got somebody else.
Well, let's work through this case first.
So I've talked to Mr. Simpson a lot, and he has some confusion of like what the case is because he believed a judge told him that he was done with everything.
Yeah.
Which is a part of the reason why he was having issues registering because he said the judge dismissed everything.
You recognize that guy?
Yeah, I recognize him.
Who's that?
Look like me.
It is you.
Yeah.
It's your case. So we'll get through it. You have more hair now.
Yeah, I need to cut it off again.
Okay. You like the bald look.
Yeah.
Let's go forward with this plea. Ms. Nix is going to put you under oath and ask you some questions. Make sure you answer her questions, and then we'll keep going, okay?
Okay.
All right, Ms. Nix.
Mr. Simpson, please raise your right hand. Do you swear or affirm that any testimony or statements that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name.
Michael Anthony Simpson.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
65 years old.
How far have you gone in school?
I graduated.
High school?
Yes.
Is English your native or dominant language?
Yes.
Do you understand that you've been charged with the following offense? 4 counts of failure to register as a sex offender?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
I already have pleaded guilty to the, not guilty to the charges.
You did when we did the arraignment, and today is what we call a change of plea hearing. And what Ms. Rios is telling me is that you are interested in now saying, all right, I want to work this out, so I'm going to plead guilty. Is that what we're doing today?
Yes, something like that.
Okay, good.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had the opportunity to review your rights with your attorney?
Well, the attorney I had was an African guy years ago.
Remember when I talked to you just now, Sad, we went over the rights, the things you're giving up, and we talked about, and you said you understood them. Those are the waiver of rights. Remember we just talked to that outside?
Mm-hmm.
Yeah, that's what she's talking about.
Ms. Nix just wants to make sure that you and Ms. Rios, the woman standing right there, had a chance to talk about what your rights are in connection with this case. And it sounds like you guys had that conversation outside the courtroom just this afternoon, or maybe this morning. Is that correct?
Yes.
Okay.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the case with your attorney, Ms. Rios?
Yes.
So the question was, do you need more time? Do you want to go outside and talk with Ms. Rios? No,
I'm
you're
fine
good?
with it right now.
Okay.
Are you satisfied with her services?
Yes.
Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
Do you waive any and all defects in the indictment for purposes of the plea?
Yes.
Mr. Simpson, do you remember having been arrested on these charges?
Do I remember being arrested on them charges?
Yes, sir.
To the jail for these charges.
I came to jail for peeing indecent disposal, and they had a hold on me for them charges.
Okay.
I want to pause for a sec. I'm sorry to interrupt, but I just noticed there was a re-indictment in this case. Are we going forward on the 01 or the regular case?
It should be the 01. I believe that the other ones have already been null pressed.
So the other ones is one case. So it is still there. 25 SC 005919 is open, and actually the final plea calendar lists this case, but in looking at it, I noticed, it's been reindicted. And there's the reindictment from November of last year. It's the same counts. I don't know what changed in the reindictment, but I want us to be clear on the record which one's going to be a plea and which one the state is going to be dismissing.
It's sorry, it says null press on my end. I don't think it says null press on the.
On the official end, it does not say that.
That judge?
That's okay. So you've dismissed the non-01 indictment?
Correct.
And we're going forward with the 01. And it is different from the original indictment in what way?
The underlying charge for the sex offense was incorrect on the original indictment.
Okay, it listed an 03 indictment, and now with the new one, it lists the Y18224?
Correct.
Okay, got it.
The indictment was registration for a certain period of time, which is now lapsed. The Y indictment was lifetime registration.
Got it. Okay. But it's the same dates that Mr. Simpson allegedly didn't register on these dates in May. I guess it's his birthday each year.
Correct.
Okay, I understand. But for the record, we are proceeding under indictment 25 SC 005 919-01. Same charges, failure to register. The state just cleaned something up. Everything else is good to go. Back to you, Ms. Nix.
So for the record, I'll authorize 25 SC 005919. And this plea, we're going forward on 25 SC 005919-01. Okay.
Great.
And I don't remember where it was. Sorry, Judge.
Well, I know you asked him, does he need more time? Because he said yes, but then he told us he doesn't need more time. I don't know how far you got past that.
I think the next question is, Mr. Simpson, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
I don't think she did. Did?
Yes.
She told you the lowest sentence you could get and the highest sentence you could get. But Ms. Nix is going to tell us anyway. So let's listen to see what she says.
All right. So the lowest sentence you could get is a 5-year sentence, and the maximum sentence is a 30-year sentence.
Okay.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? The state recommends a 10-year sentence to each count, probated, and each count will run concurrently with each other. Do you understand that's the state's recommended sentence?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
Not right now.
Well, it turns out, I know you didn't remember it, but you are on probation in that other case, because we're going to talk about it at the end. That was this aggravated battery, aggravated assault situation. Okay?
You understand that your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence?
Yes.
Excuse me. A 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial.
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of 4 counts of failure to register as a sex offender in indictment number 25 SC 005919-01?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes,
Do you understand that if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal as outlined in OCGA 5-6-35 within 30 days of today?
yes,
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, and since these are felonies, you have only 4 years from today to do so?
yes,
Judge, had this case gone to trial, the state would expect the evidence to show that on or about May 12th of 2022, May 12th, 2023, May 12th, 2024, and May 12th, 2025, the defendant failed to report for his annual registration appointment on his within 72 hours of his birthday, as he is required to do based on a 2001 conviction for aggravated assault with intent to rape in Fulton County. And this occurred in Fulton County. The defendant has 9 prior felonies. He has 2 prior registry violations, one in 2011 and one in 2012. He has a rape conviction. That's the conviction that requires him to register. He also had a aggravated assault conviction, which did require him to register for 15 years while he was on probation. That was a part of a negotiated plea that got, in which the state dead docketed a sex offense. And so that's why the state offered 10 years in this case.
Okay. Got it. So the issue was a failure to register, not you're at an address and you didn't tell us the new address. It's just you didn't come in for your annual checkup, but for
Correct.
4 years.
He did not, last time he registered was in 2021.
Got it. Okay. Mr. Simpson, do you know where to register?
I went to the sheriff department today to register.
Good. So you're current now.
Yeah, I'm there now.
All right. Ms. Stallworth, when was Mr. Simpson's most recent cycle?
Let me, Your Honor, I just had written down what I she had already called out. Hold on one moment, I'm sorry. So the last was the September the 9th, the failure to register in 2025, and then before that, a probation violation. But the most recent conviction was the one that he's on probation for.
Got it. Thank you.
You're welcome.
Ms. Rios?
Yes, Your Honor. Mr. Simpson is 65 years old. He has some mental health struggles that he's on disability for, and he's had a lot of housing struggles too. The only reason that he is actually here today is because luckily I had his niece's number and she went and found him to give him my number so he could call me to make sure he's here today. But since then, I've been communicating on the phone, and so I believe won't have trouble registering before it. So there was a few things that were confusing for him. He believed a judge when she told him to terminate one of his probations before that, saying that
everything was done.
And so when we first met with him, Jill, he was like, "What are you talking about? Everything was done." So I had to go back and get like the original stuff in the docket to show him like, it wasn't done, because he was really confused. So all this is still really confusing, what's going on. I think he understands now what's happening, but he misunderstood, and that's what caused him not to register. And I think at some points he was in custody, and that's so like I'm not sure if every year he was out to be able to register.
He was in for 400 days on the case that he's on probation for now, but I think that predates this, but he's working through some challenges.
Yes.
I hear you.
And so I told him to make sure he gets proof every time he goes to register, and he has some proof that he got there. So I think he's on the right track now. Hopefully his niece will still be able to help. And if if I hear something, maybe she can remind him, but he's old.
like he's struggling with a lot, but I believe he wants to stay on track. He doesn't want to be in custody. He just wants to be able to live his life. And so
Okay.
I'm hoping that we can do the negotiation, but with a 4-year behavioral intensive date, because 10 years is a long time to be on probation. I understand his history, but for someone at 65 to be on probation for 10 years is a lot.
Until he's 75.
Yes, Your Honor. So I'm hoping that we can do a behavioral incentive date with 4 years. If he reports for 4 years, I think that's a good show that he's doing what he's supposed to be doing. And then we can terminate the probation.
Okay. All right. Mr. Simpson, where are you staying these days?
201 Washington Street.
Tell me what's there.
They got shelter there, they got housing there, they got identification where you get vouchers to go get them for free.
Great.
They got voucher for EBT and stuff like that.
How long are you able to stay there?
No, I've been staying there since I got out.
Okay. So
they bonded me out there. And
Well, that was my next question is how did you were in for almost 4 months.
Yeah.
How did you make bond?
Oh, my niece bonded me.
Oh, your niece helped you.
Yeah.
Okay. All right. And then you went from the jail to
that location.
201 Washington.
Yeah, and he told me to stay there, and every time they check, I was there, and then I started reporting to him. So he gave me a telephone number to call so I could stop walking down there.
Okay.
It's right down the street from me.
Okay, but you're allowed to stay at the 201 Washington.
Yes.
Longer if you want to.
Yes.
Okay. All right. What's your birthday?
May 12, 1960.
Okay, but May 12th is the magic part. So every time you've got a birthday, May 12th, you got to come register.
Okay.
Every time. You're 100 years old, you still need to register.
Okay.
So be thinking, for my birthday, I want a cake or whatever you like to have, and I got to go see the sheriff.
Yeah.
So that place you went today, you need to go on or about your birthday, May 11th, May 13th, but make it around your birthday. Because if you don't, then these charges pile up. Now, the first one you missed, you actually were in jail. You're right. Part of the 400 days for the case for which you're on probation. You turned whatever you turned there, 61, while you were in jail. So you couldn't register. But all the years after that, you needed to have registered like you did today.
Okay.
So when it's your birthday, register.
All right.
No judge can make that go away unless there's a real fancy order that's written out, and then you get a piece of paper that you'll be able to show, look, I don't have to register anymore. And you don't have that piece of paper. Okay?
All right.
All right. Do you have questions about anything we discussed?
No, sir.
Do you get disability?
Yes, I get SSI.
SSI, good. And does that go to your niece? Does it go straight to you?
Me.
Goes to you. Does it go to you like on a green dot card or?
On Direct Express card.
Okay. And do you use some of that to cover costs at 201 Washington?
No, I had moved from that area over there to Ben Hill, but I ain't like the situation was going on in there, so I moved back to 201 Washington Street. And I was trying to find something else because I'm like, the shelter, it closed today. It stayed open, I think, 2 months, and it closed today. And really, I don't like shelters, and so it's over. So I'm really trying to wait till I get my check, and seeking I find somewhere else to stay besides there.
All right. I think that covers all that I wanted to cover. I find there's a factual basis for your plea. You did miss a few registrations. And I also find that your plea is knowing and voluntary. Ms. Rios, can someone in my office sign the indictment?
Yes, sir.
For you? And Ms. Nix, can we sign?
Yes, sir.
And Mr. Simpson, it is okay if we sign your name to the indictment for your guilty plea?
Yes, sir.
Great, we'll do that. Here's how I'm going to sentence you. On count one, I'm actually going to dismiss count one. That's the year you were stuck in jail. You could not have registered that year. But for counts 2, 3, and 4, I'm going to sentence you to 10 years to serve 3 months with the balance probated. on each of those. You've already served your 3 months. You're not going back into custody today. And you'll be on probation for the rest of that time. I'm going to make your probation, I'm going to waive your supervision fees because you are on a very limited budget and that budget comes from the government. I'm not going to make government pay government. So you don't have to pay supervision fees. I'm not going to set a behavioral incentive date, but I'll be very open to probation coming to me after a few years saying, hey, Mr. Simpson's doing just fine, assuming you're doing just fine.
Yes,
But that means that on your birthday, what do you have to do?
go register.
Go register with the sheriff. That's right. Every year, no matter what year you're turning, you need to make sure you register. And that's it. Keep in mind that if you move, and moving's fine, if you find a new place to live, you got to go register.
Yes, sir.
So you register every birthday and then each time you move. And so if you find a good spot in Ben Hill or somewhere else and I'm planting my feet here, this is where I'm going to lay my head to rest. You got to go to the sheriff and say, new address, 123 Walnut Street, wherever that is. Okay. And then we stay out of your hair. If you choose to shave it, we stay off your scalp. But you just need to make sure you let people know where you're staying and then on your birthday.
Yes, sir.
There's one last piece, and that is in case 21 SC 179995. I'm going to revoke 3 months of your probation, but you'll get credit for that time you've been in because you weren't registering while you were on probation there. How much time? You said 5 years and 3 months. I think I'm going to terminate that one because there were no special conditions on that one. I thought there might be given the charges, but it was just a palm case. This probation extends beyond that. So we're closing out your probation in that older case. You're on probation in only one case.
Yes, sir.
Case you had with Ms. Rios, it's the one because you didn't register. Okay?
Not even a no contact?
No, there was nothing in there. I know. I was surprised. Ms. Nix, anything else from the state?
We'll just not cross the count one if he was in custody.
Yeah, that's what I sort of did it for you, but yes. Okay. Anything else, Ms. Rios?
All right, thank you.
All right, Mr. Simpson, before you leave, you got to meet with Ms. Simpson. Probably no relation, but you never know. And she is with probation. She's going to give you reporting instructions.
Okay.
That's your next hot date. Your first one was to go to the sheriff today, but she's going to give you a piece of paper and it has a date and a time when you have to go to the probation office to say, hey, I'm here, and do your intake.
Okay.
Do you know where the probation office is?
No.
Okay, what's going to be on there? It's a couple blocks from here, so on Memorial Drive.
Okay.
Okay?
All right.
But it'll be on that paper. Don't lose that paper, and maybe tell your family where that place is too, so they can help you remember.
All right.
All right, thanks.
Thank you.
That's my last case, Judge, may I be excused?
Yes, ma'am.
Thank you.
You bet. Take care of yourself.
Oh, I'm sorry. I'm sorry. It's not old.
What did she do?
She said 65 is old. 65 is not old.
No, that's the new 30.
Spent that so much time.
Patrick Williams and Howard Favors. I'm good. Yeah.
We're doing the final plea.
Yes.
They just reached out to her and she didn't tell me there was like an issue on your floor, so she's gonna reschedule, okay? Okay, all right.
All right, let's get on the record with Mr. Roby. It's 25 SC 006 000. Mr. Roby is here in court with Ms. Wood. Mr. Body represents the state. Mr. Roby, good afternoon.
How you doing?
I'm doing okay. How are you doing?
I'm doing well, then.
Good. We're gonna have a quick conversation about your case. Make sure your lawyer has all the discovery, the evidence that she's entitled to. We're gonna see what the state's offer is. Because you're charged with murder, we don't usually work cases out through the conversation we're gonna have, but I'm gonna have the state get on the record what its offer is if you were interested in entering a plea today. And if you're not interested in taking the state's offer, then we move your case to a trial calendar. And you're actually on 2 different calendars coming up soon because you've been in jail for a long time, and we ought to try to get a jury to hear this case as soon as we can, okay?
Sure.
Ms. Wood, do you feel like you've got all the discovery in the case?
Yes, Judge, I do need to tell you about a little hiccup. I did tell Mr. Abadi about it. So we had done the contact, can you stop?
No, you're
Okay,
good.
sorry. We had you signed a contact order for my investigator to set up contact visit for him. My investigator ended up having to go out on maternity leave much earlier than she anticipated. So
Everything is okay?
yes, she's
Good.
good, baby's good. But then of course that interfered with her plans to see Mr. Roby, so she passed that off to a different investigator. I unfortunately saw in the system where that investigator had seen Mr. Roby earlier this month, so I thought
Everything's great.
And so when I met with him today, he said actually like they called me out, but they never like took me anywhere. And so I just reached out to her. She said yes, she had it lined up that day. There was an issue on his floor. They asked her to reschedule, and then she's been so busy running around for me and other attorneys, she has not rescheduled it yet. So he has not actually seen his digital discovery. He's very interested in seeing it. Let Mr. Bonnie know. I think I can have it done before the 23rd trial calendar. I just don't know if I can have it done for Judge Emerson's trial calendar.
Okay.
So that's my request.
Is the digital discovery pretty central to what's going on in the case?
I would say yes. Like there's a lot of cell phone records that I just can't print out that
Got
need to
it.
be reviewed.
It's not so much, hey, look at this surveillance camera as it is, look at what this
There
phone
is a very important video.
that he should see also.
Yes,
Okay.
for sure. But the cell phone records is the thing that I was like, I just can't get all this out.
Yeah. So are you sharing that to say we shouldn't do final plea yet? Because really, Mr. Roby hasn't had a chance to digest how strong or weak the state's case is? Because I'm all right with that too. I just wasn't sure where this was leading other than please don't put us up in front of Emerson.
He and I have gone over what I've been able to go over with him, so
Mhm.
he understands the magnitude of this case. So
Yeah.
I think we can go ahead with final plea. That's fine with me.
Okay.
I just want to let you know about the discovery issue.
Got it. If I see that we are trending towards getting onto the Emerson calendar, the other thing we could do is what I discussed with Mr. Wallach, which would be to have Mr. Roby brought over here. And that way he could watch it. You wouldn't even need to be here, or another investigator could sit, but as long as there was a device and a way to play or flip through the cell phone records, then we could address that, a way that might not be as much of a scheduling challenge for you. But let's see how that goes.
Okay.
We've had one continuance on the Emerson calendar so far, but you're still a little ways away. So, Mr. Roby, I'm going to ask the prosecutor to share with me what he would recommend if you entered a plea today. I'll make sure you understand it, and then you can tell me, yep, that's what I want to do, or no, sir, I'd like to go to trial. Okay?
Okay.
Mr. Abadi, if Mr. Roby wanted to resolve the case today, what's the state's recommendation?
The offer of life, Your Honor.
Okay, it's pleading to the indictment. Got it. So, Mr. Roby, the state at this point is not inclined to reduce anything to a voluntary manslaughter or something else. And you would, if you wanted to plead, you'd plead straight up to the indictment. The lowest sentence I could give you in that instance would be life. It would be plus 5 years for this gun charge. But that's life with the possibility of parole. The difference is if you go to trial and you're found guilty, I don't know that you would be, but if you are found guilty, the state might then advocate for life without parole. And I have the discretion to go in either direction, life or life without parole. They're both very, very large concepts. You're not eligible for parole for 30 years if you plead to murder or you're found guilty of murder. Life without parole would mean you're not ever eligible for parole. So they're big things. Have you thought about whether you want to plead to the indictment as is?
No, I do not want to plea.
Okay. Then what we'll do is move you to trial. That doesn't mean you forever can't. The fact that you said, no, you don't want to plead today doesn't mean you cannot change your mind. It may be after you watch this discovery and whatnot, you nudge Ms. Wood and say, hey, we need to try to work something out. And if you guys work something out, that's great. And I can take that plea. The only thing that changes from today is you don't get to withdraw your plea if the sentence I give you is more than what Ms. Wood asks for. Just like at trial. If you're found guilty at trial, you don't get to say, I don't like that sentence. I want a new trial. You're stuck with the sentence you get if you're found guilty. Going forward, you could raise your hand and say, I want to plead. I don't want to make the victim's family go through this, and I'm a work the case out. You just would be stuck with whatever sentence I gave you. Does that make sense? Yes?
Yeah.
Okay. I'll work with your lawyer about getting you here to watch discovery if we start getting into it. Hey, we might be able to get you in front of a jury sooner. But Ms. Wood is on her own going to be figuring out a way to get herself or an investigator out to the jail so that you can watch with that person this discovery that you haven't been able to see so far. Mr. Abadi, anything else for the state? Okay, Ms. Wood, anything else?
No, Judge, thank you.
All right, either way, Mr. Roby, I'll see you soon. You are on the April 23rd trial calendar, so you'll come back for that call of the calendar. The trial wouldn't start till that following Monday. That's a Thursday, but that would be the latest I'd see you. You're on this other trial calendar that I mentioned. You wouldn't see me, you would definitely see Ms. Wood, but that would be not next week, but the week after. So don't be surprised if you get put back on a bus sometime soon coming over here.
Okay.
All right, thanks.
All right. Have a nice day.
You too.
May I be excused?
If you're done.
I'm done. To Calvin and.
He seems like such a nice guy. What are you prosecuting him for murder for? Is this little guy who's friendly? You're free to advocate. College students, where are you guys from? Georgia State. Is this part of a class that you got sentenced here? Oh, he can come on out. When we finish taking this, we can talk a little bit about American criminal courts. Sure. Ms. Rios, is this a plea with Mr. Andrews?
Yes.
All right, how you doing, Mr. Andrews?
I'm all right, sir.
Good. I'm gonna let the prosecutor get situated and then we'll get going. Then
Family member on Zoom.
there is no, there had been some people on, but now it is our family of the McBurney Chambers. And Ms. Stallworth, who's an honorary member. Deputy Gordon, I have a wedding here at 4:30. Did I tell you about that? We have a wedding at 4:30. And I did a Rule 22 because someone's bringing in a camera, like that kind of thing. I figured they'd need it. So we might have a little hiccup at like 4:15. It's not a large group, but you're welcome to stay. My guess is you have to, but they'll be happy to see you. But that's our one thing when we're done here. All right.
How did they land on this courtroom for their nuptials?
This guy was a juror.
Oh my goodness.
He's like, hey, would you marry me? And I didn't know he was a juror. He explained, here's the connection. He says, you're probably going to say no, but I was a juror, and I'm like, yes.
Places you could get married.
Yeah, maybe I'll have him sit in the jury box for it too. Relive the agony. Let me know when you're ready. You're ready. Okay. Ms. Rios, you guys ready?
Yes.
Okay, let's get on the record. This is position 11. 25 SC 0000719. State versus Calvin Andrews. Mr. Andrews is in court with Ms. Rios. Ms. Smith is here as the prosecutor, and Mr. Andrews, we're gonna work through the conversation about a plea, okay?
Yes, sir.
Ms. Smith will put you under oath and then ask you a bunch of questions. They're not trick questions. Answer them truthfully as best you can. And you need to let me or Ms. Rios know if at any point you've got questions of your own. Will you do that?
Yes, sir.
Okay. Ms. Smith?
Yes, Judge, thank you. Mr. Andrews, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Calvin DeWarren Andrews.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
45, 12th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of this indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Andrews, do you remember being arrested on these charges?
Yes, ma'am.
State is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No, ma'am.
Ms. Rios, is this negotiated or non-negotiated? Mr. Andrews, do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that's recommended by the state up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yeah.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, bless you.
Bless you.
The right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yeah.
Mr. Andrews, has anyone forced or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 000719, how do you plead to count 1, possession of crack cocaine, and count 2, possession and use of drug-related objects?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal your guilty plea conviction? But if you believe that there's been some type of error in your guilty plea, that you can apply to the appropriate appellate court for a discretionary appeal?
Yes, ma'am.
Do you understand that that process needs to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Thank you, Mr. Andrews. Your Honor, if this case were to proceed to trial, the state would show that on February 7th, 2024, Sergeant Hallman, that's Holleman of the Atlanta Police Department, was patrolling in the Winster Street area, that's in Atlanta, Georgia, and also in Fulton County, when he saw a car that had a large windshield crack, and also the person that was driving the car had their seatbelt behind their back instead of across their chest as it should be. Because of this, the officer initiated a traffic stop. When he initiated that traffic stop, he did smell marijuana coming from the vehicle. The person that was driving was identified as the defendant, Mr. Andrews. Mr. Andrews told the officer that he did not have any marijuana in the car. However, he did smoke some of the marijuana earlier that day. At that time, the officer then searched the vehicle based on that raw odor of marijuana. On the driver's side of the vehicle, where the windshield meets the roof, the officer was able to locate a suspected crack cocaine bag and also a bag of suspected marijuana. The officers then weighed this narcotics that they found on the digital scale that they had. Inside of that suspected crack cocaine bag that the officers found, there was an estimate 10 smaller bags within that bigger bag of crack cocaine. The officer, in addition, located a razor inside of the bag with the crack cocaine. At this time, the defendant was placed under arrest for having crack cocaine and marijuana, and he was arrested for the charges we have here today. These are the facts of the case regarding the state's recommendation. The state is recommending a sentence of 5 years to serve 1 with the balance probated. We're asking for that 1 year to serve just based. Most of it is based on the defendant's criminal history. The state has a concern of the defendant reoffending again. We believe that there is a high risk of reoffending. We did file a recidivist notice in this case, but that recidivist notice highlights the 2006 and 2008 possession of cocaine charges, convictions that the defendant has. Also, there is a conviction from 2017 for possession of cocaine with the intent to distribute. In this case, the defendant was given 3 years of probation that would have ended around 2020. Just a year after that, when his probation ended, the defendant was arrested for possession of cocaine with the intent to distribute. That case happened in 2021. However, he did plea in 2024, pled guilty to that charge. And then we have the case that we're talking about here today from February 7th, 2024. It does post date that guilty plea he entered into for the possession of cocaine with the intent to distribute. However, the concern here is that even after the defendant was arrested for this case, he was let out on bond, and in July of 2025, the year after, he was picked up again for possession of a controlled 2 substance. Mr. Andrews was in court before, and we asked a question about drug court and why he didn't want to go to drug court. And he stated that his drug abuse is not crack cocaine. He doesn't use it for personal reasons. So because of the history with the possession with the intent to distribute and having the cocaine on other occasions, the state does believe that there is a high risk of reoffending. And because of that, we are asking for 1 year of custodial time with the balance to be on probation. And that is all from this. Oh, it's not all from the state. Regarding those special conditions of probation, the state will be asking for the defendant to complete a drug and alcohol evaluation with treatment if necessary, for there to be a Fourth Amendment waiver, for the defendant to complete 40 hours of community service, for the defendant to be gainfully employed, and for the defendant to not have any drugs that are not prescribed. And that's all from the state, Your Honor.
Got it. Thank you. Ms. Stallworth, I have some information because of the recidivist notice and the repeat offender notice that were filed. Tell me how many total cycles you have, please, and then what the most recent conviction is.
I have 23 cycles total. The most recent is the open case, the 25 PI 006002, the possession of marijuana less than an ounce and possession of a Schedule II. And then, as she stated, the case on probation, the 23 SC case. I'm also showing an active warrant out of Morrow for a probation violation. The date of that warrant was March the 10th of 2026.
10 March 26. That's a fresh warrant. Okay. Can you give me that PI number again, the 25 PI, please?
Yes, 25 PI 006002.
Thank you.
You're welcome.
Okay. Sorry, it's slow in opening up here. Oh, you got a bond. Okay. Ms. Rios.
Yes, Your Honor. Mr. Andrews is 45 years old. He's from Georgia. He has 4 children. And yet the youngest ones are 10 and 14, and he's very active in their lives. He takes them to school. He gives them their lunch. He's like the main caretaker when he's at home for these children. And he hasn't seen them since he's been incarcerated for 9 months. He's also on disability for foot damage. This is charged as possession of cocaine. It's not with intent. They're not accusing him of selling. I'm asking for the in custody time to be 9 months. Now, he's fine. He said like they can give me additional probation. He has no plans of messing up. He just really wants to be out to see his children and able to be an active dad in their lives. He also indicated that like this wasn't his car. And so we did talk about that and how that possibly would go at trial. So that's why he's entering this plea today. But he's been in custody for 9 months at this time for a possession charge. So that's why I'm asking that whatever probation amount he's fine with, he just wants to be able to get out and see his children. And he was supposed to have his, is it your fiance? On the call, but she's not.
She may have been on. There were some names I didn't recognize that were on a while. Oh, there's an Alexis Pollard.
Yes, sir.
Okay, she's back on.
She might want to speak on his behalf.
Okay, Ms. Pollard, are you able to hear us?
Yes, I'm able to hear you guys.
Okay, are you connected to Mr. Andrews?
I am.
Okay, what do you want to tell us, if anything, about Mr. Andrews?
What she is stating is true. He actually helps me because I work 16 hours a day, 5 days a week. So he's the one that actually get his 2 children, and he's the one that spends time with them. And lately his son has currently been acting out because he hasn't physically been able to interact with him. He does talk to him on a daily basis, but he's so used to interacting with him. And I can say that I am here to help him with anything that he may need to stay out of trouble.
The 2 children, 10 and 14, are they also your children, or they are important in your life?
No, they are my children, my daughter and my son.
Got it. And they are also his children?
They are his children.
I'm sorry, there was a noise in here. They're your kids, but he helps care for them, or you and he
I am the biological mother. He is the biological father.
Got it. Okay. Understood. They are your kids jointly. Has Mr. Andrews lived with you the last 10 years?
Within the past last 10 years, yes, but within the last 4, I end up losing my house.
Okay.
So we had to split household, but he currently help far as pickup because my son goes to a school that's not in his district, and we actually share the drop off. I drop off and he picks him up and keeps him in the evening for me, being that I work 16 hours a day.
What do you do?
I am a security guard at the airport, and I am also a security guard with Delta Security.
Got it. All right. Well, thank you, Ms. Pollard. Appreciate you getting back on the call.
You're welcome, Your Honor.
Mr. Andrews, what's up with a warrant in Morrow? Does that ring a bell?
Just because I've been locked up for 9 months and it's a driving on suspended license, and I have to pay them like every month, and then since I've been locked up, I haven't been there.
You haven't been paying. Okay. You've got 4 kids. I've heard about 2. The 2 that stay with you and Ms. Pollard. Are the other kids younger or older?
They're grown.
They're adults. Are they in the Atlanta area?
They not in the Atlanta area.
Okay. Ms. Rios said that you get disability, something about your foot. What's this?
I have nerve damage in my leg. Like my toe, I can't move my toe.
Okay. Is it difficult for you to stand, or are you okay?
I'm all right.
Are you able to do some work or no work?
I'm able to do some work. It just be a little difficult. I'm able to do some work though.
What kind of work do you do?
I like work at like a little grocery store. You know what I'm saying?
Okay.
Like do a little sweeping and stuff.
Okay. Ms. Smith, are you withdrawing the recidivist notice for purposes of this plea?
I am, Your Honor.
Ms. Simpson, is Mr. Andrews on probation in another case, but this incident happened before the plea, or where are we?
So the PI case, put him in violation. This case did not. The
Okay.
PI case did, and he's already been revoked for Judge Foreman in November.
For the PI case? Okay, got it. That's the marijuana with the co-defendant. All right, so I guess he's caught up, if that's the right term. And Mr. Andrews, I guess we talked about this before because it was the first thing I wanted to talk about this time. You've thought about drug court, and you don't think drug court is something you need because you don't use this cocaine that you keep getting arrested with?
No, sir.
You sell it?
I used to.
You used to sell it? Okay, but you don't sell it anymore?
No, sir.
All right. Were you the only person in the car with the cracked windshield at the time you got arrested?
Yes, sir.
All right. Anything you want to add?
No, sir.
Okay. Well, Mr. Andrews, I find there's a factual basis for your plea. I'll accept it. Find that your plea is knowing and voluntary, meaning you've understood what we talked about. No one's forcing you to enter this plea. Ms. Rios, can someone in my office sign the indictment for you?
Yes, sir.
Ms. Smith?
Yes, Judge.
And Mr. Andrews, can we put your name on the indictment indicating your guilty plea?
Yes, sir.
All right. I am going to sentence you on count 1 to 5 years to serve 1 year with the balance on probation, and count 2 will be 12 months to serve to run concurrently with count 1. You will get credit for all the time you've been in, not just now, you were in before, and then you got a bond, then you got arrested again, but all the time you've been in since February 7th of 2024, you get credit for. So you're not going down the road. You've got a little bit of time left here in the county jail. Special condition of probation number 1. Where is home? When you are out and you're going to be with Ms. Pollard, is that in Fulton County or a different county?
No, it's just in Atlanta.
It's in Atlanta?
Yes, sir.
But is it in DeKalb or is it in Fulton?
Fort.
Okay. All right. You're going to, once you get out, while you're on probation, you're already on probation, but new conditions for this case. 1 will be within the first 2 months, you have to sit for a drug and alcohol abuse evaluation. And if that evaluator says that you would benefit from some treatment, whatever that treatment is becomes part of your probation. Number 2, you're going to have a Fourth Amendment waiver, meaning probation can search you if they feel like they need to, or your car, or whatever you got. And 3, you will need to complete within the first 6 months of probation 40 hours of community service. But you can work with probation on what that is. I don't mean for it to be difficult for you because of your foot condition. There are lots of different ways to do community service. Doesn't mean walking by the road, picking up trash. There are other ways to do it. And I encourage you to do something that is most comfortable for you.
Yes, sir.
So I think that's the right outcome, given the criminal history. And you actually can go deal with Morrow now and be getting credit on your sentence. Because you weren't going to leave, even if I said time served. That warrant from Morrow means we got to get you down there so you can deal with that. Okay?
Yes, sir.
The sentence that I imposed is a little higher than what Ms. Rios asked for. And so you should talk with her because you can say no, thank you. If you want to instead go to trial, we can put you on the trial calendar that's coming up in the next month or so. If you want to do that, or you can decide, hey, this closes this case out. It's not exactly what I wanted, but I'll take it. So why don't you talk with Ms. Rios and then let me know what you want to do. Okay?
All right.
Okay. Ms. Rivers, if you want to take a quick break, he'll come out, say whatever he says. We can get that on the record when you come back. And I think we just have one left is the other Williams will be a plea. All right, we'll do that in about 5-6 minutes. So back to you guys. American criminal courts, something like that? Okay. What year are you at GSU?
I'm on a second year, I graduated 2026, but I have a lot of school to do.
Second year, you're in law school.
No. Undergraduate.
Okay, they don't say sophomore anymore, they call it second year?
Oh, yeah, sophomore.
Okay, all right. And you?
I'm a second year as well.
Okay. And a part of the class was to come watch court?
Yeah.
Excellent. How many hours do you have to watch?
It really doesn't matter. I mean, it's more like a semester long kind of project. So, I go in and out of courtrooms, just collecting, information, comparing that to what we learn in class.
How close does it match? Is it pretty different from what you learn in class?
Yeah. I'm actually learning a lot more that I have questions on.
Oh, all right. And do you get to go back to the professor and say, hey, we were in court and this happened. What the heck is going on?
That's at 9:30.
Oh, it's tonight?
No.
Oh,
Tomorrow.
okay. Got it. So you're going to go in and say, shh, let me tell you.
Yeah, and then we have to write a four-page paper on everything that we collected throughout the semester.
Huh?
Yeah.
When does the semester end?
Pretty soon, actually, in the next few weeks, I think 3 or 4 weeks.
Okay, well, good. So Ms. Rios, we'll get it officially on the, I won't make Mr. Andrews stick around, but we're taking a quick break. But we'll just get the answer and then we can put it on the record when Ms. Rivers comes back. Does Mr. Andrews want to go forward?
Yes, sir.
Okay. Mr. Andrews, in a moment, Ms. Simpson is going to come talk to you about reporting for probation. You'll end up, you should already have a probation officer, do you?
Miss Simmons.
Okay, you may keep the same one, but because this is a new case, you're going to have to go to the probation office when you get released and just report so they can do intake. But then it's, even though it's probation for 2 cases, it's just going to be 1 officer. You only have to do things once. Okay? Good luck with everything. Do you all have any questions about what happened today? Okay.
Yeah. So my first question, I really just wanted to know like the positions and the roles of everybody in the courtroom.
Sure.
As the clerk, and I already spoke to the bailiff and.
That guy right there? Yeah. So the prosecutors sit at the table closest to the jury. So Mr. Abadi is a prosecutor. He's with the major case division. So he handles murders and stuff like that. Ms. Smith is what, I don't know, they're different titles. I say line ADA. She's assigned to my courtroom. Mr. Abadi's in lots of courtrooms. He goes where the big cases are. But Ms. Smith handles all cases assigned here. As someone gets indicted, the case is randomly assigned. There are 15 judges who handle criminal cases. And so it goes McBurney and then Smith and then Jones. The cases assigned here that are not murders or certain specialized cases, Ms. Smith handles all of them. That's the prosecution side. The defense sits at the other table, and most defendants in Fulton County are indigent. They cannot afford their own attorney. And so they have appointed to represent them one of the two public defenders in this courtroom. Ms. Rios is one, and then Ms. Wood, the red hair, she's the other public defender. And they divide up the cases based on the number of the indictment. I think 0 through 4 is Ms. Wood, and 5 through 9 is Ms. Rios. So they randomly divide them up. But that way they get about the same number of cases. Every once in a while, there's a defendant who can afford private counsel. That person would still sit there. You saw Mr. Wallach. He was here with Mr. Williams. So Mr. Williams hired Mr. Wallach to represent him. But the defense attorneys sit there. Court reporter right here. Ms. Simpson occupies the jury box, handling all the probation stuff, and then just doing background research on, hey, this guy has a warrant, that kind of thing. And then you may have seen a couple times Ms. Nelson came out. She is the litigation manager who works with me and gets kind of schedules everything. The clerk of court is a different office. They don't come into court. Ms. Nelson, in some ways, does some clerk type work, but she works for me rather than for the clerk. I don't think there were a whole lot of other players who were here.
Thank you.
You bet.
Okay, sorry.
That's all right. You can have a few more, and we'll wait till Ms. Rivers comes back.
So I remember you mentioning your sentencing and everything, but I'm not really familiar with what you mean by like 5 years to serve 1 month and et cetera. Could you explain that, please?
Sure. Sentences can be in custody, prison. They can be on probation, or they can be suspended. If you are in custody, it's what it sounds like, you're behind bars. And if the sentence is more than 6 months, you're probably going into the Department of Corrections. So you're gonna get on a bus, taken down to a intake facility that's near Forsyth, Georgia, about an hour south. And then you go to some prison in Georgia. That's where you serve your time. Most non-serious cases, you get probation. And so you might, some people, as you saw, they walked in, they got their sentence, they walked out. They have probation. And so they're going to be supervised. And if they get arrested or get in trouble while they're on probation, they can go back to jail. But if they're doing okay, then they just have to check in with their probation officer, and they're not having to go to jail. A suspended sentence, you don't report to anyone. There's just a clock ticking, and when that sentence expires, you're all done. There are not a whole lot of suspended sentences. It's usually probation or jail, but you can get what's called a split sentence. And that would be like the gentleman, Mr. Anderson, who just pled. He got 5 years to serve 1 month, 1 year, 5 years to serve 1 year, balance probated. He's done about 9 months, so he's got a few more months that he's got to serve. Because it's less than 6 months, he'll probably stay at the county jail, it's a few miles from here, and then he'll be released. He won't be in jail anymore, but he'll still be under sentence. He'll have probation for 4 more years. It's 5 years to serve 1 year, balance on probation. 5 minus 1 is 4, so he's got 4 years probation. And so then when he's on the probated part of his sentence, it's gonna be just like the people who came in and left. It's probation. You just had to do some jail time first. Every once in a while, the sentence is just prison, especially if it's a big number. This guy who is facing the murder charge, he was able to plead to life if he wanted to, and that would be you go to prison, life with parole, you go to prison for 30 years, and then you might get paroled out. So, but most cases, there may be a little bit of prison or jail followed by some probation. And those were those 5 serve 1 month, 5 serve 3 months, 5 serve a year, and then the rest of the sentence is probation.
And you don't typically handle women like that. Sorry, I answered that myself.
Good job.
Okay, I have one more question. What's something you think people should know more about criminal courts? Like in your opinion, what's something that's commonly like misinterpreted or informed the court will?
I'd say a couple things. One, most folks who are coming in here facing charges have actually done something. It's very, very rare that it's the wrong person or nothing happened at all. But it's not always what's charged, because the police write it down one way, the prosecutor charges it one way, and then when everyone gets together and they talk about it, like, oh, you were here for one of those. Maybe that wasn't kidnapping, but you hit your girlfriend real hard, and that's assault. So charged with kidnapping pleads to assault. That guy did something, but maybe it wasn't exactly the way it got charged in the indictment, because people don't have perfect information up front. The state continues to investigate, sometimes after the indictment, to learn more, or they did their investigation, but the defense knows some information that the state didn't have. And when they present that information, oh, look at that, the story's a little bit different. But it is seldom that the person comes in and says, I did nothing and I had nothing to do with it. Every once in a while, but generally the police don't just randomly arrest this guy and say, you shot someone. The closest that comes would be there's a car with 4 people and they arrest all 4. Well, there's only one gun in the car, so there's only one, that gun belongs to only one person. But what we typically see is maybe all 4 get arrested, and then a prosecutor looks at it and says, you know what, the way the law works, if you are the driver of the car, you're kind of on the hook for most of what's in the car, especially if you're not only the driver, but the car's registered to you. If it's a stolen car, maybe you don't even know what's in the trunk. But then the prosecutor has the ability to say, we're going to dismiss the guy who was in the back seat, because you know what, the gun was underneath the driver's seat. Not only was he not driving and the car's not in his name, he was sitting in the passenger back seat. But the officers, they're just sort of reacting and they do some arrests. And then the prosecutor's office says, we're not going to move forward with the charges against that other person. Last thing I'll say is that, and you got to see it some, there's a story and a life behind every defendant. It is easy for people to say, oh my gosh, he got charged with this, he should go to prison. But then you learn a little bit more about the situation, and that person is a father or a caregiver or this or that. And it's important to weave all those things in there as well when you think about what is the right disposition. And if we send this person to prison for a year, that's a penalty and punishment, and he may be deserving of that. But does it have collateral effects? What happens to the household he supports? Does it inadvertently punish the kids because he was the main breadwinner? Or does it punish the grandmother that he takes care of if he gets taken out of circulation? And punish is the wrong word, but does it make life more difficult for those people? And that's not a reason to say, well, you're immune from going to jail because you have kids. Plenty of people who get sentenced to prison have kids. They're often not very active in those kids' lives. But it is helpful to hear from the defense a more complete version of who this person is, because we are all more than our worst day. And I see people often who are dealing with the consequences of their worst day, where they had too much to drink, and instead of walking away from a situation, they took a chair and broke it over someone's head. And that's a bad choice. And you might have really hurt the person who you hit in the head, and there are going to be consequences for that. But if all you're thinking about is that one instant, then you say, yeah, you should go to prison for 10 years for doing that. But there's more to these situations. So when you're reading about cases, it's flat, it's dry. You're reading the paper, and you aren't seeing the people. You don't have the victim coming in saying, let me tell you how bad, I didn't just get hit over the head with a chair, but I have blurry vision now. I was a pilot, I can't fly anymore. And so no, I only needed 5 stitches, but I lost my career because this guy hit me with a chair. Oh my gosh, I wouldn't have known that just by reading the indictment. That's even more serious. And so when the defendant says, what's the big deal? All I did was hit him with a chair and he punched me first. Well, the big deal is this guy lost his livelihood because of what you did. And so that's going to have more consequences. So that may have been more words than you wanted, but.
Thank you. No, it was perfect. Thank you.
Perfect.
And thank you everyone else for having us on fun.
You bet.
Okay, have a good day. You too.
I didn't read.
Oh, sorry.
I still about
Oh, like this. He's like.
It's the safe zone. Let's see if we can get Ms. Rivers to come on out, and we'll handle our last case.
Yes.
He took the, he accepted the plea.
We did. We'll get that on the record when you're ready. Are you still in his? Okay. Ms. Rios, we're just going to wrap up the conversation we were having with Mr. Andrews, your other client. He doesn't need to come back out. We're good. I just wanted you to affirm on the record that you spoke with Mr. Andrews and he wants to persist in his plea. Great. All right. Now we'll turn to Mr. Williams. This is our final plea for the day, position 7, 25 SC 005-677. State versus Patrick Williams. Mr. Williams, good afternoon.
Yeah.
He is here in court with his lawyer, Ms. Rios. Ms. Smith represents the state. And Mr. Williams, Ms. Rios tells me you're ready to enter a plea. Is that right?
Yes, sir.
Well, that's what we're going to do. Ms. Smith will put you under oath. Please answer her questions and please let me know if at any point you've got questions of your own.
Were both cases on the calendar, or is this a plea to 2 cases? But
Is it? Okay. What's the other case number? Did you know that?
Yes.
Okay. What's the other case number?
SC 004703.
Did you know you were pleading to 2 cases?
Yes, sir.
Okay. One of them is terroristic threats. That's the 677. What's the 703? Entering auto. Okay. You're going to be pleading to 2 cases and I'll hear about both of them. And if I accept your plea, I'll give you a sentence in both of them. Okay. When you're ready, Ms. Smith.
Thank you, Your Honor. Mr. Williams, please raise your right hand. Do you swear or affirm
That the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Patrick Andrew Williams.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I take medication for schizophrenia, but I'm not under influence in the alcohol or drugs.
Did you take your medication today?
Yes, sir.
Do you take it in the morning or at night?
In the morning and night.
Both. Did you get it this morning?
Yes, sir.
When you take that medication, does it make you woozy or drowsy?
At nighttime, it kind of do, but
It helps you sleep at night.
yeah,
But the morning one doesn't wipe you out.
nah.
Okay, you feel like you understand what we're talking about here.
Yes, sir.
Great.
Mr. Williams, how old are you and how far have you gone in school?
I'm 31 years old and I graduated high school.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Williams, do you remember being arrested on these charges?
I remember the auto entering that was about 2 years ago, about a year and a half ago. And this new charge, yeah.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 8 months with the balance probated?
Yes.
Do you understand that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, even on a federal case?
Yes, ma'am.
Are you currently on probation?
Not that I know of.
And are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Williams, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 005677, how do you plead to count 1, terroristic threats and acts, count 2, willful obstruction of law enforcement officers?
Guilty.
And as to indictment number 24 SC 004703, how do you plead to count 1, entering automobile or other motor vehicle with intent to commit theft, and count 2, loitering and prowling?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal your guilty plea conviction, but if you feel like there has been some type of error in your guilty plea, that you can apply to the appropriate appellate court to request a discretionary appeal?
Yes, ma'am.
Do you understand that that has to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Thank you, Mr. Williams. Your Honor, if this case were to proceed to trial, starting with the indictment ending in 5677, the state would show that on June 12th, 2025, Atlanta Police Department officers responded to a criminal trespass call at 1217 Metropolitan Parkway, Southwest Atlanta, Georgia. That's in Fulton County, and it's also the location of a Chevron Food Mart. When the officers got there, they were met by the defendant in this case, Mr. Williams. He started to shout at them that he would kill the officers and that he would shoot the officers. These statements were made to the officers when they tried to make contact with the defendant inside of the Chevron Food Mart. The officers then had a chance to speak with the owner of the food mart, who advised the officers that the defendant had been causing a disturbance that entire day at the store, and that they called the officers for some type of assistance to remove him from that location. When the officers tried to arrest the defendant in this case, he started to flee. However, he was apprehended after a short foot chase. The defendant was then placed under arrest for the charges we have here in the indictment ending in 5677. For the indictment that ends in 4703, if this case were to proceed to trial, the state would show that on June 6, 2024, officers with the Atlanta Police Department responded to I got it in here, so. They responded to the Fire Station 14 fire station that's in Atlanta, Georgia, also Fulton County. When they got there, they spoke with firefighters who were at that location. They said that a black male jumped the gate and was breaking into vehicles. One of those vehicles that were broken into was Lieutenant Ryan Orrin Jones. They advised that Mr. Jones advised that when he went back to his car that night, he opened the trunk and the defendant was there sleeping. He then saw his compartments and his car opened and saw that his cologne and glasses were missing. The officer was then advised by the people at the location that the defendant was walking down Lee Street. The officer then canvassed down Lee Street / Arlington Avenue, where they were able to make contact with the defendant in his case that matched the description of the person that was breaking into the cars. The officer then also found the cologne and glasses found on the person of the defendant that belonged to the victim in this case. At that time, the defendant was placed under arrest for the charges we have in indictment 4703. Mr. Williams stated that he was in the car that day sleeping because he was trying to find some type of safety, and that's the reason why he was in the car. I did get a chance to speak with Ryan Jones, the person whose car was broken into that day, that firefighter, and he did say he didn't have a issue with the offer that we were given as a global in these two cases, and that he's moved on from that situation. However, those are the facts and circumstances in the indictment ending in 4703. Regarding the negotiated plea between the state and defense, we've agreed to a global sentence of 5 years to serve 8 months, balance probated. With the balance probated, it's my understanding that the defendant has already served the 8 months, so it'll be credit for the time he's already served. Regarding the special conditions of probation, the state is recommending for the defendant to complete an anti-theft course, an alcohol and drug abuse evaluation with treatment if necessary, for the defendant to stay away from that Station 14 firehouse, to also stay away from that Chevron Food Mart, for him to have no contact with I may take that one out because Mr. Jones may respond to an incident. For the defendant to be gainfully employed, and not a condition, but encouraged for the defendant to participate with PAD. I believe that Ms. Rios told me that he has been accepted. So just encouragement on him working with PAD.
Sure.
And that's all from the state, Your Honor.
All right. Ms. Stallworth, what can you tell me about Mr. Patrick Williams?
He has 10 cycles total. There is a 2021 first offender conviction from Clayton County for fleeing or attempting to elude, giving false name, DUI, and driving without a valid license. There's a 2019 first offender conviction out of Fulton for robbery by intimidation. There is a current probation case, 21 SC 179341, for criminal damage to property second degree and terroristic threats. And then a 2022 FTA out of Coweta. Nothing further.
Thank you. And thanks for your help today. You are good to go. This is our last matter.
You're welcome. Thank you.
Ms. Rios?
Yes, Your Honor.
Well, let me ask Ms. Simpson first. It sounds like there's an open probation case. You're not sure? You've got the furrowed brow.
I'm looking.
Okay, you look into it while Ms. Rios tells us about Mr. Williams.
Yes, right. He's 31 years old. He does not have any children. He has been accepted to PAD. He is on SSI for his mental health struggles, including schizophrenia. I do want to say, I think we cannot do the requirement that him be employed, because sometimes being SSI messes that up. And he has a brother that's going to take him to the PAD program. He has ambitions of wanting to get a job at some point, and hopefully doing business. A moving business, he said, or construction. But first he wants to make sure he's getting his benefits and set that up. And it seems like he is self-medicating, but PAD helps with all those services. So he'll be getting that treatment with PAD, and I think he'll be on his feet. He's told me that he wants a better life and doesn't want to be involved with any of this anymore. So I'm hoping that you accept the plea as negotiated.
All right. Mr. Williams, tell me what you know about PAD.
I know it's a program that it helps, like, It helps. I know it helps you get your disability started. It can get you in the ACT team program, which I was in the ACT team before.
You were with Grady Act? or-
Graded ACT.
Okay,
They told me they gonna get me back in graded ACT team.
good.
I know they give you somewhere to live. Right now I'm homeless, so there'll be
Do you have family in the Atlanta area?
I have a lot of family, but we are separate ways.
Okay, got it. Well, PAD could be very helpful. I hope you take advantage of that. Were you on benefits for a while, but you lost them because you've been locked up?
Basically, yeah.
Okay, but PAD can help you get them started up again.
Sure.
Got it. Okay. Do you have any questions about anything we've talked about?
I got a question about probation, but she told me to ask it when I go there.
Okay. You are are we on probation? We're not on probation.
The case name 5677 was a violation, and he had a revocation in September, and Judge Carnesale terminated the penalty.
Okay, so that one's closed out because of Judge Carnesale's ruling. Did she also revoke some time so that Mr. Williams is stuck?
He had revoked 5 months, which looks like.
Oh, he's done that, so we're covered. Okay, got it. So you are going to be back on probation, but it'll be probation for these two cases and not an older case. But Ms. Simpson or Ms. Rios can talk to you about probation. You're going to get out in the next couple days, so you're going to need to report to probation, and you'll get information about where to go and when you need to be there. You don't want to miss that first meeting. That's another thing PAD could help you with. If you go to PAD first off when you get out, that would be a wise move, because they will start getting you connected with your benefits, maybe with supportive housing, and they'll certainly, and ACT, Grady ACT. But you will need to go to probation in a few days after you get out, okay? All right. Well, Mr. Williams, I find there is a factual basis for both your pleas. The one where I think you were clearly working through an episode and you were at the Chevron station and you fussed at the officer. And then a year earlier, when you were at Station 14 in that fire responder's car. Also find that your pleas are knowing and voluntary. You are taking medication, but that medication helps you understand what's going on and keeps you stable and focused. And I noticed that throughout our conversation, that you were very alert and understood and comprehended what was being discussed. And I find that the plea is voluntary, meaning no one's forcing you to enter these pleas. Is that true?
Yes, sir.
Okay. Ms. Rios, can someone in my office sign both indictments, the surprise one and the one on the calendar?
Yes, sir.
Ms. Smith? All right. Mr. Williams, can we sign your name indicating your guilty pleas to the two cases?
Yes, sir.
All right, we'll do that.
You want me to sign it or you?
No, we're going to electronically sign your name if you say yes.
Oh, yes.
Yes, we'll do that. Okay. In 25 SC 005 677, I am sentencing you on, it's count two a misdemeanor or it's a misdemeanor, he ran. Okay. Count one, I'm sentencing you to 5 years to serve 10 months with a balance on probation. Count two is 10 months to serve. So those are going to run concurrently with each other. In your other case, the 24 SC 004 703, it's 5 years to serve 10 months on count one, and then 10 months to serve for the loitering. Those will run together, and then both cases run together. So it's basically 4 years and 2 months of probation because you've already done your 10 months in custody. You will get out, not today, it's too late in the day, but you will get out tomorrow, maybe Thursday. But we'll push that paperwork along. Special condition of probation in both cases. Number one is that you submit to a drug and alcohol abuse evaluation. And that's just a way to figure out if there's any kind of treatment that would benefit you, that would make sure you take the medicine you're supposed to and not the drugs that you're not supposed to. You also will need to stay away, in one case, but really the whole time, from that Chevron station. And if you can get that address to Ms. Nelson. And in the other case, Station 14, which is a fire station, and that address will be in your sentence as well. Don't go around either of those places. If you need to go to a food mart, go to one of the thousands of other food marts around here, go to a different fire station. And I'll ask that probation assign you a mental health officer, someone who is attuned to your needs, is going to know what the ACT team does, and will be particularly supportive of the things you're trying to do to stay focused and stable and avoiding episodes like these. Okay? Ms. Rios, anything else on behalf of Mr. Williams?
Thank you.
Ms. Smith, on behalf of the state?
Nothing further.
Okay. Let's get on the record the reporting instructions, and then Ms. Simpson, I know you'll meet with Mr. Williams to tell him more.
It'll just be to report within 48 hours. We're gonna classify him as homeless, given that he is in the process of work with that. He just needs to make sure you update your address once has assisted you with placing you in housing.
Okay.
If he gets out on Thursday, your office is closed on Friday for Good Friday, so he shouldn't panic. He could just come on Monday. Okay.
They're not open on the weekend?
They're not open on the weekends. Normally they're open on Fridays, but this Friday is Good Friday.
I'd be able to come Friday.
Well, but they're not open. So you should go Thursday if you can. You ought to get out tomorrow, which is Wednesday, and then just go the next day. Go Thursday. But it could be that there's a hiccup or they think you have a warrant. It takes a while to clear it.
I'll make sure I call and see.
Okay. And it's just the latest you should go there is next Monday.
Yeah.
All right. Because they're going to be expecting you. And if you don't show up to do the intake, then they just send me a warrant and we don't need that. Okay. Do you have any questions about any of the things we discussed?
Oh, sir.
Okay. Ms. Simpson's going to come talk to you.
All right, thank you so much.
That's the address.
Thank you, everyone.